foreign students would return to their countries as friends and ambassadors of our nation. Dr. Majumdar, himself a professor of botany, chose the name Symbiosis, the word biologists use to describe a mutually beneficial relationship between two living organisms. The guiding philosophy behind his endeavor was Vasudhaiva Kutumbakam, or the world is one family. Today, the Symbiosis sapling has grown into a large tree. In 2002, Symbiosis was accorded the status of a university. Symbiosis International University's campus on Senapati Bapat Road in Pune, the first campus of Symbiosis, is a landmark in the city. Dr. S.P. Majumdar also established a memorial and a museum in Pune to commemorate the life and ideals of Dr. Baba Saheb Ambedkar. Symbiosis is also known for its unique Afro-Asian Cultural Museum, a treasure trove of cultural, historical, and artistic heritage that showcases the beauty and diversity of various countries. Over time, Symbiosis has come to dwell not just within the walls of its many institutes, but also in countless hearts the world over. Symbiosis is the laughter of students and the quintessence of education. A world-renowned, multicultural, multilingual, and multidisciplinary educational institution, Symbiosis now has state-of-the-art campuses in Pune, Bengaluru, Noida, Nashik, Hyderabad, and Nagpur, with plans to have campuses in other nations as well. The university hosts thousands of students from each and every state and union territory of India, as well as international students from a number of countries around the world. The university has multiple institutions in diverse disciplines of study: law, management, computer studies, medical and health sciences, media and communication, humanities and social sciences, engineering, architecture, and design. The university is also in the forefront of research in diverse areas such as advanced legal studies and research, waste resource management, stem cell research, nanoscience and nanotechnology, medical image analysis, behavioral studies, applied artificial intelligence, entrepreneurship and innovation, research in media and creative industries, Center for Ambedkar Studies. Over the years, Symbiosis has excelled in three avatars: culture, education, and health. Physical, mental, social, and spiritual. Symbiosis truly embodies the transformative vision manifest in the country's national education policy aimed at creating global citizens with Indian values, which has also been the focus of Symbiosis throughout its illustrious journey of more than 50 years. In keeping with the university's larger social commitment, the Medical College and the 900-bedded state-of-the-art Symbiosis University Hospital and Research Center are dedicated to serving humanity. This is evident in their commendable service to people in the many villages and hamlets around the lovely campus. These institutions have been instrumental in ensuring the well-being of the community, especially during the COVID-19 pandemic. Symbiosis Community Outreach Program and Extension, or SCOPE, is working towards the sustainable, comprehensive, and integrated development of the villages located in the vicinity of Symbiosis International University's main campus. The university continues to attract a multitude of well-known leaders celebrities, personalities. A lesser-known facet of Symbiosis is the wealth that Mother Nature has bestowed upon it. The university campus at Lovely is home to a large variety of flora and fauna. In March 2022, on the proud occasion of the Golden Jubilee of Symbiosis, the Honorable Prime Minister of India, Shri Narendra Modi, inaugurated Symbiosis Arogya Dham.
50 years ago, the idea germinated in my mind to promote friendship and understanding between foreign and Indian students and thereby promote international understanding. Today, we are celebrating golden jubilee of this golden idea.
कि 50 साल की आपके पास एक ऐसी पूंजी है, अनुभव की पूंजी है, अनेक एक्सपेरिमेंट करते करते आप यहां पहुंचे हैं। एक खजाना है आपके पास, ये खजाना भी देश के काम आएगा। आप फले फूले और यहां पर आने वाले हर बच्चा अपना उज्जवल भविष्य बनाने के लिए आत्मविश्वास के साथ निकल पड़े। बहुत बहुत धन्यवाद, बहुत बहुत शुभकामनाएं।
For Symbiosis International University, the world was, is, and will always be its family. Vasudhaiva Kutumbakam.
Check, hello, check. Check, hello, check, test. Check, 1 2, check. Yes. Hello, check. Hello, check, test, 1 2, check.
आ रहा है
हाँ वो पूरा क्लियर कर रहे हैं डायरेक्ट आने के लिए।
Just students are settling in, so we'll be for 5 minutes. Students are requested to quickly settle down. Students are requested to settle down and remain silent. Symbiosis Law School, Pune, under the aegis of Symbiosis International Deemed University, is proud to host a celebration of Law Day every year and aim at encouraging our students and alumni to imbibe within themselves the spirit of law and our Constitution. We take this opportunity each year to reaffirm the aims and aspirations of the Constitution we have given to ourselves. We started the public lecture series in memory of late Justice Y.V. Chandrachud from the academic year 2010-11. This year, we are glad to host Honorable Dr. Veerappa Moily, former Chief Minister of Karnataka and 2 times Union Minister, as the chief guest for the Law Day celebration, and also to deliver the Justice Y.V. Chandrachud Memorial Public Lecture on reflections on Nyayashastra and the concept of justice as a prelude to Vidhi Manthan. Honorable Dr. Veerappa Moily will also administer the Law Day oath, which will be followed by a short interaction with the audience. This year, as a part of the Law Day celebrations, we are holding a symposium on the theme Vidhi Manthan, Bharatiya Gyan Parampara in Law and Justice, organized in collaboration with PRAVAH. On the dais today, we have our Honorable Chancellor of Symbiosis International Deemed University, Professor Dr. S.B. Majumdar, our chief guest, Honorable Dr. M. Veerappa Moily, former Chief Minister of Karnataka and former Law Minister, Government of India, Professor Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, and Dean, Faculty of Law, Symbiosis International Deemed University, and Mr. Shantanu Lamdade, State Coordinator for PRAVAH. I request the dignitaries to proceed towards the watering of the Bilwa sapling as we commence this program. Thank you very much. I request the dignitaries to take their seats. To deliver the welcome address, it is my honor to introduce Professor Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, Dean, Faculty of Law, Symbiosis International Deemed University, Jean Monnet Chair Professor, Fulbright Scholar, AHRB Fellow, UK, and a former member of the Law Commission of India. Professor Dr. Shashikala Gurpur, with an illustrious career over 32 years in teaching, research and industry, has been with Symbiosis Law School, Pune since 2007. She is a distinguished academician and orator, featured amongst the illustrious 100 women personalities in the book The Phenomenal She, launched by the Indian National Bar Association, and was listed amongst the 100 legal luminaries of India in 2016. Dr. Shashikala Gurpur has been conferred with the annual Kittur Rani Chennamma Award in 2018-19 by the Government of Karnataka for her excellent achievement and contribution in the field of education to women empowerment. Dr. Gurpur has more than 85 publications and presented more than 330 invited lectures, workshops, and seminars across the globe. She is a distinguished visiting professor at the WB NUJS, a member of the Academic Council at MNLU Aurangabad, a resource person at the National Judicial Academy Bhopal, and a PhD referee to many NLUs. She is awarded with the most coveted professional achievement, Jean Monnet Chair Professor for EU Climate Justice Law, Governance, Management and Policy, co-funded by the Erasmus Plus program of the European Union. She is a team member of the Global Evaluation and Accreditation IALS USA. She has guided more than 15 PhD and 100 plus master's thesis students. She is the lead in a Spark project, 4 EU grants. She's a part of the NADFM training and the MCCIA committee. Most recently, she has been selected as a member of the Task Force on Sector-Specific Group on Digital and Creative Economy set up by the Ministry of Education, Government of India. She has successfully led the Symbiosis Law School, Pune, to be amongst the 5 top law schools in India, with robust internationalization, quality academics, and research. I invite you, ma'am, to deliver the welcome address and report of a path since 2022.
Namaskar. Good morning, Honorable Chancellor, sir. The Chief Guest, Honorable Dr. Veerappa Moily, the former Union Minister and former Chief Minister of State of Karnataka, Mr. Shantanu, who is representing our knowledge partner, the collaborator in this great, first of its kind of event in Symbiosis Law School, Pune, the PRAVAH NGO, and all the dignitaries who are seated among the audience from the NGO, our own home team of faculty and staff, students, resource persons, students from outside of Symbiosis who are all here, a very warm welcome to each and every one of you. Today is a very auspicious day for many reasons. First of all, we celebrated the inaugural with the Shivoham concept, which is about that every one of us is Shiva, the auspicious one, and it is a dispassionate, a kind of, understanding our completeness, somebody without beginning, without an end, and always eternal, the truth. So, with that auspiciousness, many states in India are celebrating the dawn of the new year in the name of Vishu, Bisu, and so many names. Just yesterday it was there. So we thought we will celebrate the gifts of nature, and especially we put Lord Shiva in the center because in the Holy Trinity of Hindu faith, Lord Shiva stands for justice. What our Honorable Chief Guest always advocated, the creative destruction in the dance of Nataraja. So we thought there is no other symbolic, deep understanding of justice than reform in terms of removing the old and beginning the new. So this deliberation today, which is also seeing a recombinant event in terms of the celebration of the Law Day Oath, which we usually do on the Constitution Day on 26th of November. Due to our academic terms going haywire due to COVID-19, we had to always place it in such a way that our resource persons are available. So we are seeing that. And we are celebrating our public lecture event, which is an annual event for a very long time, with the support of an anonymous donor. It began, but now we have the onus as a university to conduct it as beyond the classroom kind of learning. And we recombined it also with a very path-breaking beginning in consonance with the new education policy, in creating and discovering and realigning Indian knowledge system or the Bharatiya Gyan Parampara in the field of law and justice. As I welcome each and every one of you, first of all of you have watched the Symbiosis film, the footsteps traversed by our honorable and very revered founder, Dr. S.B. Muzumdar sir. A warm welcome to you, sir, for all your blessings, for what you have given to the humanity, not just to the city of Pune, to India, but to the whole of humanity, and the way in which you are still steering all of us to be innovative as you are, to serve the humanity in its full sense of justice to the expectations of the young population and readying them for future. Warm welcome to you, sir. Honorable Dr. Veerappa Moily, who is decorating this dais as a chief guest, will be delivering his address in terms of public lecture, which is also going to be a prelude to the proceedings that are going to follow on the theme of today in terms of Bharatiya Gyan Parampara on law and justice. Sir's forthcoming book on Nyaya Shastra of India is going to be a great beginning, and I'm sure that what we are going to do today in terms of culmination in possible curriculum for future, this book will be the major resource, I'm sure. And we have been talking about this idea ever since Sir was the law minister, and we were discussing in many meetings that, Sir, how could we look at creating our own definition and accent of justice with the oldest civilization that we are, beyond the veil of various invasions or imperial influences that our legal system and justice concept carry. So today has come the day to deliberate on that in the land of Pune. I will talk more about it when we start the panel discussion, but I would like to put as a prelude 2 points. In India, this exclusive discussion on law and justice in terms of Bharatiya Gyan Parampara or Indian knowledge system has happened a couple of months ago only, in Benares Hindu University, where 2 days proceedings elaborately discussed on different legal disciplines such as international law, environmental law, constitutional law, criminal law. But by want of time and entering the fag end of academic year, we did not want to do that, especially when we were collaborating with a social service organization. We thought with the Moily sir's availability, he was very kind to be available despite his personal commitments in state of Karnataka. We thought that we will keep one-day event which would lay the seeds of a course, or maybe a master's program, or maybe a module for faculty training for future with today's deliberation. Because in Symbiosis, we don't do anything which is irrelevant, which is without the outcome. So it is Vidhi Manthan, which is a churning. You know, when Samudra Manthan happened, Lakshmi came out, when the churning of the ocean happened. So today we are doing the churning of the oceanic minds who are available here as resource persons from different disciplines ranging from history to political science to technology to active work in the community, in the Dharmashastras, to the legal experts, the jurists, to come out with, at the end of this Vidhi Manthan, or brainstorming on the idea of law and justice, to come out with the Navaneet, or the butter. What is that butter? The curriculum, the possible curriculum outline. By about evening, we will be able to charter the skeletal framework for a curriculum, which could be modified as a value-added course or as I already told, a training module or skill-building module. Let me also welcome you to this deliberation. As part of this, as I said already, a recombinant event, the idea that why Vidhi? How the word Vidhi carries a significance for us. How do we use the word Vidhi? In a pejorative, negative context, we will be using Vidhi as the fate written on the forehead, which is unchangeable. But there was a term called Vidhijna. Vidhijna was the word used as an alternative word for Kautilya or Chanakya, who wrote the famous Arthashastra and sets of 4 books, which became the manual for governance. Now, he was called Vidhijna not only because he had the knowledge of rules, he was also called the Vidhijna because he knew the fate of India through the Maurya Empire. He rewrote the fate. From the Nandas, he snatched the governance to the hands of Mauryas. On the dais, we have 2 eminent personalities who are Vidhijnas. Dr. Muzumdar Vidhijna in the sense of changing the fate of so many faculty, so many students, touching so many communities in India and abroad. Sir, you rewrote the destiny through the language of education, through the means of quality education. The second Vidhijna we have on board as the chief guest is Dr. Veerappa Moily, who by actively involving in 6 ministries, 6 times MLA in Karnataka, including the towering role of being a chief minister who wrote the destiny of first national law school in the country, facilitated the electronic city destiny of Bangalore, and then as the 2-time MP and multiple ministries that he was engaged with and the 2 ministries that he led, he wrote the law. He wrote the first land reform law in Karnataka. He wrote the he facilitated the drafting of the Companies Act in 2013, among other things, which many of you may not know. And then he also was very instrumental in conceptualizing from the dais of Symbiosis Law School in 2010 when Sir came for public lecture, the very idea of Indian legal service and Indian judicial service in the line of career judges and career lawyers, as we see in continental legal system. So a man of many innovations, which primarily came from his role as a lawyer, as an advocate, not only for law and justice, but also for the cause of the downtrodden people, marginalized people. Dr. Moily has been a Vidijna in many ways. They say that a Chakravarti is the one who turns the wheel. Sir has written a book called Wheel of Justice. So turning the wheel is not just a wheel, it is the wheel of justice, as we see in Symbiosis, in its core values of Vasudhaiva Kutumbakam, based on which we also have rolled out a course on Vasudhaiva Kutumbakam. So I always feel when we rediscover this in today's public lecture, in today's Law Day oath, in our commitment to the Constitution and constitutional values, and the Vidhi Manthan, what we are discovering is our common DNA as a humanity, irrespective of our affiliation, our age group, and our discipline, in terms of the DNA of justice, the word dharma, which is very core to our meaningfulness. As later on we will go ahead with the proceedings of the day, you will see that everyone in India has their idea of dharma. And that dharma is it about sustainability? Is it about tolerance? Is it about equilibrium in personal life, in relationships? Is it about harmony? So there is always a rediscovery and readjusting of this balance in the dance of Nataraja, which we are today exploring in a very unique way. And I welcome each and every one of you for participating and in turn contributing and engaging and enriching this whole rich discourse that we have planned within the limits of time today. I must also tell, as an annual feature, the path that we have traversed. I must be very honest in disclosing to each and every one of you on the dais and off the dais that the PRAVAH, or the engagement of this flow of life in last 1 year, which we usually recount on the Law Day celebration, we had to do for 2 years, almost 1.5 years, because after Madam Justice Nagaratna, who came and spoke last time on good governance and judicial trajectory, we could not hold the event in the whole of 2023 because of many other supervening priorities and the non-availability of resource persons. So in 2024, we are beginning with it for the 2023, and we hope to do another celebration in 2024, probably another dialogue with the students. We want to take new forms than just a lecture by itself as a standalone event. So in last 1 year, the path that we have traversed will show you that we are very fortunate to be ranked 3rd and then again ranked 6th in 2023 in the national ranking framework, and a number of other rankings which distinguished between private and public law schools, putting us as the topmost private law school in the country in a landscape of thousands of law schools in the country. About 1,700 odd law schools we have in the country, in all hues and shades, including 27 national law universities among the state-affiliated central university departments and deemed and private university like us. So from 2002, that we came under the fold of SIU, and from 1977, from the founding days of this law school, we have continually expressed this or stood for this excellence of topping. So let's go to the next slide quickly. This is a snapshot of the different programs we run under the law school. Today, under the Faculty of Law, we are 4 law schools. Symbiosis Law School, Pune, is the foremost, oldest member, but we have the 3 other evolving and also establishing their own imprint in Noida, Hyderabad, and Nagpur. So in Symbiosis Law School, Pune, what is unique is the number of students is almost 2,274 with 51 full-time faculty members. Double the number of that come as visiting and adjunct faculty members. We have 5 full-time research scholars, and then we have about 100 PhD scholars whom we mentor over the years. And then we have 60 plus international collaborations, grants, certificate programs which are making for area studies in terms of international studies. And our programs are very uniquely honors programs with the integrated BA LLB and BBA LLB. We also kick-started or revived our erstwhile 3-year LLB program, which is attracting graduates from MBA, engineering, and all other streams among others, which is enriching our product contribution to the society and justice system. We have a 1-year LLM program which we started in 2013. Now it is seeing 8th specialization, 9th specialization in terms of telecom, media, technology specialization, which is present only in Queen Mary University in UK. So there's a lot of interest shown in students to this new type of LLM, along with the international studies and European legal studies. We are one of the only law schools which offer this kind of a global law program. And then we have only one diploma program which acts as a value-added course. I must tell you that we have a number of value-added courses which includes and ethics-related courses, which includes contemplative lawyering program. Within the contemplative lawyering program, we look at ideas of consciousness, Bhagavad Gita, and many other spiritual dimensions, which has in a way resulted in strong value building in the law students and law graduates, because our profession needs that as the bedrock of future leadership. This slide shows you the core of Symbiosis International University, the core DNA, internationalization. This is the law school and this is the university where internationalization is very, very comprehensive in terms of its sustainable development goal alignment. And then the new program that we started, where in the 4th year, at the end of the 4th year or at the end of the 2nd year, our undergraduate law students can move to any of the collaborator, either in US or in UK, to have the pathway program, which means that by the time they finish their LLB here, they will have their LLM finished in a British or American university. This has been possible because of a long-term collaboration with the lead universities like Birmingham, which is the Russell Group University, New Hampshire University, Arizona University, which are lead universities in the US. So it is a first law school in Pune in Maharashtra, and maybe one of the 2 or 3 in the whole of India to come out with such a well-structured pathway program. We were dreaming of it when Sir came last time in 2009 itself, but we could roll it out only now because the law was cleared by the UGC only in this year. Now we have other dimensions of internationalization which you will see in terms of faculty mobility, in terms of area studies, exclusive clinical writing course, which since 2009 we have been imparting through, it is a best practice from European universities, from an American practicing lawyer. And then we have the COIL program. One of our professors who is comparing here, Professor Lasya, has led it in the past, where with 4 universities our students did the research and came out with the project in totally online way. Mind you, this was 3 years prior to COVID, so we were already ready for the online and hybrid education. And then we had the topmost law firm of the world, Herbert Smith Freehills, collaborating with the training of our students for global competencies as well as readiness for global legal careers, which has been such a good beginning that we have been able to make important strides in international internships and employments. Now today's ritual that you watched, we have been following this ritual in last event as well, Symbiv event, because we want to accentuate the value of the university in climate change awareness and environmental importance, respect for all life, sentient beings around us. So worshipping the tree was there in ancient Indian tradition, which we want to reincarnate in terms of our focused value in Symbiosis International University in terms of respect for sustainable development goals as well as environment. So we hold the Jamuni chair, which is looking at climate change law and policy in terms of EU and India comparative approaches among other projects. Let's go to the next one. So we have a heavy research funding which is coming from international and national funding. These snapshots show you how our students have gone an exchange program supported by the DAAD grant and other grants in other parts of the world. Let's go to the next slide. We have this unique innovation which came from our Pro-Chancellor, Dr. Vidhi Manthan, which is about judge scholars in residence. So you will see there retired High Court and Supreme Court judges acting as judge scholars in residence. One of them is also a sitting judge, Justice Modak, among others, and we had Justice Ravindra Bhatt, Justice Gokhale, Justice P.V. Reddy, Justice R.C. Chavan, among others, and Justice Pradeep Nandrajog, the former Chief Justice of Mumbai, all of them decorating the role as academicians when they come to this law school and mentoring students. As a result, we have had large chunk of students getting selected in judiciary. Let's go to the next slide. We see these two flagship events which figured as best practices in the NAC documentation as well. One is our own version of international trial advocacy competition, where we have international and national selected participants, top ranked law schools coming in. This is now the 8th edition that we are going into. And then we have a flagship conference called Symbiosis, Rule of Law in Context, International Conference, which attracts not less than 500 abstracts, 200 papers, and in 9 tracks we run this conference. Let's go to the next one. And this year the compendium is going to be published with Taylor and Francis, which is going to be Scopus indexed. We have this very unique Excellence Center in research, which again, sir, is a byproduct of the second generation legal reforms, which focused on legal research, because in Indian legal academia, first-hand research based on Indian realities, contributing to the original jurisprudence from Indian experience, has not been very much figuring in the global literature. So we thought through this center, which is inspired by the guidelines given in the National Knowledge Commission and later on in the new education policy, has looked at it. From 2013 onwards, we have had this center. Thereafter, or aligning with that, came other excellence centers of Symbiosis International University. So we have a very close synergy with the center. Our focal areas have seen climate law and policy, Eurasia, where we have 28 EU legal studies courses developed with a comparative perspective, Jamuni chair and Jamuni module on ease of doing business, and then we have 21st Skills Lab, among many other things that this research center has accomplished with heavy funding from European Commission as well as Indian government channels and other Indian funders. Let's go to the next slide. So this is the slide which shows how our stakeholder engagement is very strong in terms of former ambassadors, our alumni. So we held the meeting in Delhi. Our student festival with, again, another innovation of theatre and law, the law theatre, which is the innovation from our Chancellor, which came in our way in 2008. And it has seen new ways. So this year we focused on climate justice in terms of indigenous people, and with the Orissa Mining Corporation case in view. Let's go to the next slide. So we have a very robust community and national agenda. Our community service has extended to mental hospital, prisons, the underprivileged areas in Pune, alongside 27 villages in Lavale area, where a lot of mediation, legal literacy, child rights and women's rights initiatives have been taken up by our community legal service, among others. Let's go to the next one. So here you see number of slides on our student achievements, ranging from international arbitration competition to international mooting competition, national winners and runners-up in number of competitions, and alongside that in sports also we have registered victories. Next slide please. In quiz, in parliamentary debate, and Model United Nations, among other things, mediation competition, business mediation competition. If you look at our faculty, you see those young achievers in terms of Professor Kshitij Naikade as the PhD candidate, and then also he went to DAAD. Yogesh went for DAAD program. Amol Sapatnikar visited Berlin School of Economics and Law, and we presented papers in collaboration with National Law School scholars in Ireland, in Dublin, among many other credits to our faculty. Professor Jivantika is one of them. Professor Arya and Professor Ujjal Mukherjee participated in Denmark in a joint presentation. In Ireland, they contributed to the presentation. I'm only giving you a glimpses because of the limitation of time. So the whole trajectory, let's see the next slide. the whole trajectory has been, in a way, vindicated by the excerpts from the resource persons and those who have contributed as stakeholders and special speakers, such as former Ambassador Manjeev Singh Puri, who was very impressed as the Jean Monnet public lecture resource person with the work that we are doing in terms of our innovation, and also Justice Srikanth Kulkarni, who came as one of the resource persons from the Aurangabad bench of Mumbai High Court, among others. So with this, as I welcome each and every one of you, I would like to reiterate that very much in consonance with the Vasudhaiva Kutumbakam concept of symbiosis and the commitment to promoting internationalization and global understanding and unifying humanity with the quality education, we are here with you in welcoming each and every one of you to this great event, which is a recombinant version of all this excellence drive that Symbiosis Law School Pune represents. Welcome one and all.
Thank you very much, ma'am, for setting the stage with that apt introduction to the theme of the day's program. I would now like to request Professor Dr. S.B. Muzumdar, sir, Honorable Chancellor, SIU, founder and president Symbiosis, to felicitate the chief guest, Honorable Dr. M. Veerappa Moily, former Chief Minister of Karnataka and former Law Minister, Government of India. I request you, sir, to also felicitate Mr. Shantanu Lamdade, State Coordinator, PRAVAH NGO. With a master's in economics from Gokhale Institute of Politics and Economics, he is a psephologist consultant and a governor nominee Senate member of Savitribai Phule, Pune University. I request the dignitaries to remain standing for the release of the leg set and booklet of Justice Y.V. Chandrachud Memorial Public Lecture. Thank you very much. It is my incredible privilege to introduce Dr. S.B. Muzumdar, known as a visionary founder and president of Symbiosis, an esteemed multinational, multilingual, and multidisciplinary educational institution that is established with the motto of Vasudhaiva Kutumbakam, the world is one family. His journey from being a professor of botany to establishing a world-class university reflects his profound impact on international education. The Symbiosis Society has under its ambit the Symbiosis International University, the K-12 schools, College of Arts and Commerce and museums, the Afro-Asian Cultural Museum, and the Dr. Babasaheb Ambedkar Museum and Memorial. In the year 2022, Symbiosis celebrated its Golden Jubilee, and the Honorable Prime Minister of India, Shri Narendra Modi ji, graced the occasion and also inaugurated the Symbiosis Arogya Dham, a comprehensive, holistic healthcare campus with facilities and research centers for medical and allied health. Dr. Majumdar firmly believes that educational institutions are responsible for upholding their commitment to institutional social responsibility. To this effect, the university boasts a robust Symbiosis Community Outreach Program and Extension Center, or SCOPE. He is also the Chancellor of Symbiosis Skills and Professional University, Pune, Maharashtra's first skill development university, and Symbiosis University of Applied Sciences, Indore. His scholarly contributions are showcased by over 50 original research articles in esteemed national and international scientific journals. He also authored numerous books on life sciences and penned over 200 articles encompassing science, education, and youth development. Notably, Dr. Majumdar assumed the role of chairman of the educational wing of the Federation of Indian Chambers of Commerce and Industry. This endeavor symbolized the ancient Indian philosophy of Vasudhaiva Kutumbakam, the world is one family. Today, Symbiosis International University stands as a testament to his vision of promoting international understanding through quality education. Dr. Majumdar's contributions have garnered him numerous accolades. The President of India recognized his exceptional contribution to the field of education by bestowing upon him the Padma Shri in 2005, the Padma Bhushan in 2012, the prestigious D.Lit honor from Tilak Maharashtra Vidyapeeth followed in 2016, alongside with being an inaugural recipient of the Dr. APJ Abdul Kalam Memorial Award. He was specially facilitated at the hands of Honorable Minister for External Affairs, Srimati Sushma Swaraj, for his contribution to international understanding in 2018. His achievements also include the Punya Bhushan Award, the FIE Foundation Puraskar, amongst many others. Dr. Majumdar's lifelong dedication culminated in numerous other awards such as the Giant International Lifetime Achievement Award, the Rotary Lifetime Achievement Award by Rotary International, the Lion Gaurav Puraskar, and we could really go on. All of these honors are a testament to his contribution to education. I invite you, sir, to deliver the Chancellor's address.
Namaste to all. Bhishmacharya of legal system in education and well-wisher, friend and philosopher and guide of Symbiosis, Sri Virappa Moili, Dr. Virappa Moili ji, to whom Symbiosis looks upon his guidance from time to time. Dr. Shashikala Gurupur, when she was reading report, I was pleasantly surprised. And then I realized why in this college, so many students from all over the country seek admissions. I also realized why there are requests from ministers and secretaries and politicians for admissions to this college. They want law college, but they want Law College Pune, not Bengaluru, not Delhi, not Nagpur. Shashikala has been a bridge between Maharashtra and Karnataka. she is equally familiar with both the states' cultures, religions. She herself was a professor at Bangalore Law University. But since she came, her career flowered. Her career flowered so much so that Shashikala's name has become extremely popular among academia. Shashikala, congratulations for taking this college at national level. Well, what should I say about Chief Minister Veerappa Moily? As mentioned by Shashikala, he has been law minister, he has been, state law minister, other portfolios. But what I admire of him is, he is an author. He has written books on various subjects, plays, dramas, novels, and you will hardly find a politician of today writing books. He has written even Ramayana. So in good old days, politicians used to be good authors, good readers, and then they used to become politicians. I do not want to talk about today's politicians, but he belongs to that generation which valued scholarship, and that scholarship was percolated into their politics. He is responsible for many legal reforms in the country, establishment of so many law universities. And we are all lucky that on this auspicious day, he is chief guest in Symbiosis Law College. Today we are going to have Law Day. And Law Day is customarily celebrated in America. But we have been celebrating it for many, many years. Initially, sir, it was Advocate Ram Jethmalani who loved this organization, who loved Symbiosis, and we used to come to teach students regarding jurisprudence and evidence law. It was his brainchild, and along with my friend Dr. Ranade, that we also thought that why not have Law Day for us, for your India, for our country. And then both of them drafted what we call Law Day Oath, which Veerappa Moily is going to deliver to all of us. Veerappa Moily is also delivering an address in memory of Justice Y.V. Chandrachud. Y.V. Chandrachud was born in Pune, brought up in Pune, educated in Pune, and was also associated with Pune and Punekars. He was the Chief Justice of India for longest tenure, for longest time, nearly 6 years or 7 years. And as the luck would have it, his son, Dhananjay Chandrachud, is now the Chief Justice of India. He was our chief guest of convocation of Symbiosis International University. So Pune has a tradition of producing good judges since the days of Peshwas, when we had Dharmashastra Pune. And the tradition continues. I am also happy that Shashikala has organized a very interesting, what should I call, conference or workshop or whatever it is, on Vidhi Manthan. Because National Education Policy has recommended that because of Western education, we have forgotten our good ancient traditions, good Indian knowledge system. And it has recommended whether we can incorporate Indian knowledge system in our curricula. And this seminar, I believe, will go a long way in fulfilling the recommendations of National Education Commission. Ladies and gentlemen, these are the three activities which we are going to witness today. And I am glad that large number of students who otherwise miss college lectures are present today. Well, congratulations to you. God bless. Thank you.
Thank you, sir, for your continued encouragement, guidance, and support towards us. It is now my honor to introduce our chief guest for today's Law Day. Former Chief Minister of Karnataka and former Law Minister, Government of India, Dr. M. Veerappa Moily was given the portfolio of Minister of Petroleum and Natural Gas and additional charge of the work of Ministry of Environment and Forests. He was a chairman of Tax Reform Commission. He also formulated and implemented various drinking water schemes and employment guarantee schemes and housing schemes. Among the numerous books that he has authored stands out The Edge of Time, a Kannada novel, Tembare, which examines a complex cultural practice of coastal Karnataka called Bhutaradhane, or the worship of hero spirits. Apart from this, he has authored books such as Kotta, made into telefilms, Suligali, Typhoon, adapted into a film, Sagara Deepa, Ocean Lamp, and many more. He has written 4 volumes of a book called Unleashing India, which outlines how India can be a superpower in 25 to 30 years. He has also written numerous plays. He is a lawyer by profession. In 2014, has opened a law firm called Moily Law Associates. He has been awarded many prestigious awards, such as the Amin Sadbhavana Award, the Devraj Urs Prashasti, Aryabhatta Award, Murti Devi and Saraswati Samman Award, to name a few. It is our honor to have you here, sir. I'd like to invite you to deliver your address of the chief guest on the Justice Chandrachud Memorial Public Lecture on reflections on Nyaya Shastra and the concept of justice.
Good morning to all of you. I salute our great educationist, visionary, and the most innovative thinker, Professor Dr. S.P. Majumdarji, Professor Dr. Shashikala Gurupur, Director, Symbiosis Law School, and also Dean of the Faculty of Law, who is a greatest teacher of the day for the law faculty. Sri Shantanu from the eminent NGO who has associated his association with this great day of organizing the very unique workshop. In fact, I am allotted with half an hour time. I don't wear a watch. Don't be afraid. I will try to be precise, confined to the subject. And Pune is the most enlightened city of this great country, a knowledge city, which has always inspired us. Mujumdar ji, 50 years back, or many years back, he envisioned this innovative thinking, elevate the education system to the international level, and law is one such thing. I always think that, this country is great. If you go through the legacy and the history of this country, no other country is as great as India insofar as the knowledge factor is concerned. In fact, I'm always proud of it. The Vidhi Manthan, which is going to take place from just now till 4 or 5 p.m. You are going to have fruitful discussion, throw some new horizon in the knowledge sector and particularly the law faculty. Symposium is our most prestigious institution in the country, nay, the entire world. When, as a chief minister, I always thought that, the law faculty will have to be enriched. When the Bar Council of India undertook a tour to Bangalore, I hosted a dinner for them, then I suggested, why don't you think of an innovative scheme like the National Law School University? I said, I will give you money, maybe I think initially I gave 5 crores. I gave 50 acres of land in the Bangalore University campus. Said to start it. Of course, I got the brickbats in the floor of the assembly. Said, why do you give, the one law college 50 acres of land and 5 crores of rupees? For 1 week, I was criticized, and I said on the floor of the house that this is the law college of the future of India, this is the law college for the entire world. And today that word has become true, that there are now as many as 27 law school universities, and there are number of law colleges, law universities like the Symbiosis, and also many others were excellent. I always said that not necessary to have only island of excellence. We should have ocean of excellence. This is the legacy of this great country. And in fact, I have written particularly on the law side. I have written a book on the Bharatiya Gyan Parampara. It is under print now. I think maybe somewhere in June it will be published by a Delhi publisher. I've gone into the deep of it, and some of the features of that book I'm going to illustrate just now. I've written today, the word has come about Vasudhaiva Kutumbakam. I have written many books, but now I'm writing one more book called the the journey, great journey of world culture, which includes our Indian culture. And in Kannada, we have named it, I have written in Kannada, Vishwa Samskritiya Mahayana. The first volume was released last, I think, 2nd March. And ultimately, it will end up with the 5 volumes. Because our history, as a greatest legacy, as and when we make a study, research, and start writing, you realize to which generation we belong to. We should be proud of it. Not for merely illustrating it, but live up that kind of a culture which is inherited by us. Today, you have organized the Law Day Oath Justice Y.V. Chandrachud Memorial Public Lecture 2024. I have the unique pleasure of giving a unique lecture here. In fact, Justice Yashwant Vishnu Chandrachud served as the 16th Chief Justice of Supreme Court from 78 to 1985. He is the longest serving Chief Justice of India. Yes, he delivered as many as 300 judgments, I was told, as a Supreme Court judge and Supreme Court Chief Justice, which is unprecedented. Fortunately, today, we have his illustrious son, Dhananjay Chandrachud. I don't know how it struck to me when I was a law minister. I wanted to launch 2nd generation of law reforms. Then I constituted a committee headed by the present Chief Justice of India, Dhananjay Chandrachud, and sent along with other legal luminaries to Singapore to make a study. Singapore at that, you remember, 91, there was total anarchy in Singapore. No governance, both in judiciary and also administration. And at that time, a Chief Justice of that country, Singapore, he reformed not only the judiciary, but also the governance of the administration. Consequently, even today, Singapore stands first in the cleanest government, most efficient government, cleanest judiciary, most efficient judiciary, and also administration. And in fact, he is now fortunately our Chief Justice. I think he has to give a lead to the administration and also for the judiciary. I will remind him of that. So, ancient Indian judicial system, that Bharatiya Gyan Parampara, was the most secular and liberated system in the world. The saints, rishis, came out with such a justice system which can be emulated not only by the judicial system of India, but world over. But we have not adapted ourselves. That is the unfortunate thing. We could have been a model. Yesterday only we celebrated the birthday of Baba Sahib Ambedkar. He pioneered our Constitution of India. On November 25th, 1949, Baba Sahib Ambedkar addressed India's Constituent Assembly for the last time. In his speech, Dr. Ambedkar says, "I feel, however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be good lot. The factors on which the working of those organs of the state depend are the people and the political parties. They will be set up, their instruments to carry out their wishes and their politics." Who can say how the people of India and their parties will behave? Will they uphold constitutional methods of achieving their purposes, or will they prefer other methods? It is therefore futile to pass any judgment upon the Constitution without reference to the part which the people and their parties are likely to play. It is not that India did not know the democracy, what democracy is. There was a time when India was studded with republics. And even where there were monarchies, they were either elected or limited. They were never absolute. It is not that India did not know parliament or parliamentary procedure. A study of the Buddhist Bhikshu Sanghas discloses that not only there were parliaments, or the Sanghas were nothing but parliaments, but the Sanghas knew and observed all the rules of parliamentary procedures which is known in the modern times. Any democracy may sometimes confront several challenges. It's natural. One such challenge is that the people may strongly feel democracy fatigue. This is antithesis of democracy. In one of the surveys conducted by Pew Research International, has shockingly disclosed the most disturbing trend that 85% of respondents in India responded to support the idea of military rule in India. India responded to, in fact, rule by an authoritative leader would be good in India. This is what the survey disclosed. Highest, and another challenge is that the widening of income group. According to a study, 22.6% of India's national income in 22-23 went to the top 1%, the highest proportion in the last 100 years. The share of wealth among the top 10% increased from 45% in 61 to 65% in 22-23. Conversely, the share of bottom 50% and middle 40% in wealth has declined. Rich got richer, the poor got poorer. If this challenge is unattended, India will be heading towards plutocracy or oligarchy. This will lead to a disproportionate society. In the Mahabharata, it was laid down, I quote, "A king who, after having sworn that he shall protect his subjects, fails to protect them should be executed like a mad dog." Unquote. People should execute a king who does not protect them but deprives them of their property and assets, and who takes no advice or guidance from anyone. Such a king is not a king, but is a misfortune on the... And this is the Rajadharma. It's nothing but a law laid down at that time. According to Brahaspati Smriti, there was a hierarchy of courts in ancient India, beginning with the family courts and ending with the king. The lowest was the family arbitration. The next higher court was that of a judge. The next chief justice, who were called Jivika or Adhyaksha, and at the top was the king's court. Justice is not only concern of law, it is as much the concern of morality as well. This is the fundamental principle of Bharatiya Nyayashastra. There is nothing strange if the conduct of a man guilty of gross cruelty to his child is adjudged as unjust conduct. The concepts of Vrita in Rigveda are the universals of which secular law and state are the reflection. And it is again the secular law, which is there, and such, even up to, I think, end of 18th or 19th, in beginning of 19th century, the world, any countries, including European countries, they did not have law which is secular. It was theocratic law. But India had this kind of a law right from the thousands and thousands of years. This is what should go to the credit of India. J.H. Nelson of the Madras Civil Services had raised the question inverted commas, as such a thing in Hindu law at any time existed in India. Nelson made himself clear that by law he desired to be understood to speak and strictly of aggregate laws proper, set to men by political superiors, and which are commands that oblige persons generally to acts of forbearance. What he meant was the law in Austin's sense. You cannot compare our law to the European law. It is totally different. That kind of a yardstick cannot be applied at all to our Bharatiya Nyayashastra. According to principle of sufficient reason or law of causality, from ancient times, every legal system has been oriented to a specific purpose. Conception of legal regulation necessarily introduces idea of purpose. A purpose is an object to be realized. Hence, a body of legal precepts is to be studied with reference to this ideal which is postulated by a particular legal system. The ideal of law is termed justice. However, in this universal sense, concept of justice is devoid of ideological content. The classical definition of distributive justice is that of Aristotle. I quote, "Injustice arises when the equality is treated unequally, and also when the unequal is treated equally." The idea or concept of justice traveled a long distance since the emergence of idea of law on the horizon of legal history and the justice. Was Jahangir. Judicial justice was the part of his very life and religion, and in his zeal for administration of justice, he installed a golden chain of justice by which even a man on the street could at once draw personal attention of the emperor to his grievance. Muslim jurisprudence is rich in the sphere of judicial justice, as they were interested only in delivering justice to their subjects, and formalism was not to hamper them in their pursuit. The very idea of pleasure and pain is manifested through the concept of personal liberty. In fact, Katyayana, a Rishi, he said, the place where the decision of the truth of the plaint is carried on by considering the rules of the sacred law is called the Dharmadhikarana. Thus, in ancient India, the doctrine of rule of law was fully recognized and practiced, and judicial justice was administered according to law. Manu clearly says that all decisions should be according to established dharma, which meant that nobody was above law. The king and the members of his family were equally subject to law of the land along with the ordinary people. According to the story of King Bimbisara of Gupta dynasty, as recorded by Huan Sang, it is said that in order to prevent fire, which became rather frequent at the time, the king passed a law that anybody in whose house fire broke out would be banished. One day, the fire broke out in the capital itself, where the king said to his ministers, I quote, "I wish to maintain the laws of the country. I myself must be banished, hence I am going into exile." This is the noblest principles of law, where the king himself banished himself, handed over the rule to his son. With these words, the king gave up the government to his eldest son, retired forever to the forest. It is only the ancient legal history of India which is rich with such examples. It does not mean that in ancient India, administration of justice was untempered with equity. The principles of administration in justice were well established I can give a number of such instances, but suffice to say that, in fact, according to law, is ever seeking to regulate the discretion, dispensation of liberties, reconciling the freedom of one to that of the many, to the ultimate advantage of each sharer in the common stock. All these verses occur in chapter of Vyavahara Adhyaya, administration of justice. They are of importance for determining the existence of doctrine of rule of law. Justice according to law are the interdependent doctrines. These verses undoubtedly establish a democratic character of the society as envisaged Manu. The very idea of democracy, of which the rule of law and justice according to law are the result, consistent in the sovereignty of the people. In fact, in Manu, it seems that the people had the privilege to be consulted in day-to-day administration, and their verdict has to be final. People's verdict. Ultimately, the people, we forget the people while administrating justice or the governance process. But our system was not that. This type of sovereignty is certainly conspicuous by its absence in modern democracies or modern jurisprudence, where only lip service is paid to people's sovereignty. Thus, these sources established that in an ancient Indian society, the king or the state was only to administer justice according to the established law, and therefore the rule of law was recognized in a proper form and practice of Manu. This is really the Dharma which was practiced in India. Further, the modern jurisprudence regards the main source of law as custom, precedent, legislation, as the law enacted by the state as superiority over custom, law as practiced by the people. But it is only in ancient Indian jurisprudence that we found the practice and usage approved by the people even prevailed over the written law. This is the principle. The only reason of our explanation of it was that actual acceptance of the sovereignty of the people. This was a fact. See, that means democracy has roots in this country. When you find those days, democracy has no roots at all in the world over. This was a fact recognized by ancient Indian jurists, that the real sovereignty vested with the people. No written text was capable of ignoring this fact. This is the greatness, nobility of law. In conformity with the view of P.V. Kane, it can be said that studying ancient legal literature gives us hope and assurance that we have had in the past governments, administration of justice of vast empires, and we have developed theories and practices that are not inferior in comparison to the most advanced nations in the world. One example of is familiar maxim, necessitas non habet legum, necessity knows no law. With India becoming a free as it is not surprise that Indian thinkers now do not get shy about admitting shortcomings of our socio-legal philosophy, which often segregates a large section of the population to permanent ignominy. This is the pity of it. That is why our legislators or parliamentarians should think of going back to our ancestors. Again, adopt the law. It's not a mechanical term. Law is the dharma of the society. And that is how the chapter on fundamental rights in Constitution has considerably changed, transformed the social outlook of the people, but such much remains to be done. In fact, legal system of the country reflects the spiritual and cultural aspiration of the people of the country, but due to historical and political reasons, and the pollution because of the aggression by other generations, our legal system has been distorted. This needs to be corrected, and high time that we correct it. Then only real dharma, real justice can be rendered to the people of this country. Otherwise, we find all distortions. It can vary from, one eminent lawyer to another eminent lawyer, from one judge to another judge. No. The real fulcrum of justice cannot vary from one person to another person, whether a judge or a lawyer, however eminent he may be. So, Indian legal system today is without a foundation. Its roots are in the common law jurisprudence, which is imported from outside. It has to be indigenous one. The four purusharthas worked out in the law, courts of ancient India became the basis of our legal system, which gave direction to law. Principles of equality, liberty, and equal justice for all are the characteristics of ancient Indian legal theory, which can bring solace to all of us. In fact, this is what needs to be done. I, as a law minister of the country, came out with the Gram Nyalaya Act of 2008. And my intention was to establish 5,067 Gram Nyayalayas. That would have really gone back to our ancient judiciary. This has been shelved, perhaps it needs to be revived. The existence of the hierarchy of courts in ancient Indian law, is the evidence of the fact that adjective branch of law was equally advanced in ancient India as in the modern days. The minute details regarding the building of courts, etc., to be done on this basis. Judicial accountability, I again thought of bringing a judicial accountability bill, which is very much in consonance with the judicial accountability of that time. Again, this bill has been shelved, and in fact, judges who were corrupt and gave wrong decisions were liable to pay fines and even face corporal punishment according to Kautilya. Now, which judge you find? There is a provision called impeachment in the Constitution of India. How many people are impeached? What happens to the number of judges, who indulged in this corruption and also partiality? If the Sabhyas, that is the judges, along with the Chief Justice, adjudged cases in a manner contrary to smatis and custom, perhaps due to fear, greed or friendship, he was liable to pay price for the fine paid by the party that was affected. Vishnu, Dharmashastra and Brahaspati Sutras are very strict and prescribe banishment and forfeiture of all property in case the judgments are perverted. And if they give an unjust decision or take bribes, in the same way, strict punishments are prescribed for the other officials, as far as even a scribe who take dictation of the judgment, he is punished. A punishment meant for a thief prescribed for them. If he takes up dissimilar position from the original one, dictation or sabya that makes use of such a deposition knowingly. There appear to have been a few instances of bribe taking in ancient India. We find an instance of bribe by a judge in Dasa Kumari Charita to ensure fair and impartial justice to all. Deterrent provisions were made to make the administration of justice free from corruption. Should we not go back to those ethics of dharma? This is one of the lessons we can learn from the ancient Indian legal system, that all efforts should be made to free the administration of justice from corruption at all levels. And this is why I was intending to bring a judicial accountability bill, incorporate some of this, the law. It is really an irony that the corruption in the modern age is not lacking, even though we claim to be more civilized. The ancient Indian legislator, philosophers were very keen to give a body of rules which could ensure fair and impartial justice to all, which can only be a characteristics of a highly developed legal system, which we inherited. Even the Judicial Standards and Accountability Bill, I was inspired to bring that bill, and in line with the Bharatiya Nyaya. During my tenure as a union, I brought it to ensure greater accountability and transparency in higher judiciary, in keeping with the great tradition which we possess in the Bharatiya Nyaya. And avoidance of delay. In fact, if precedent is found in the ancient Indian literature, in which a king was to suffer the consequences for causing delay in deciding a dispute. King suffered. He could not have delayed. But now you see civil disputes or the criminal, how many years it will take. In the Ramayana, a king named Naga was to decide the ownership of dispute between two Brahmins. He delays it. As a result, king had to abandon the kingdom. This is the great, legacy of law which we enjoyed. The anecdote appears in the Mahabharata to explain what a king must do, his duty, in settling disputes without undue delay. If he spends his time enjoying earthly pleasures instead, it would amount to dereliction of duty. Now, judges, they want more pleasure trips, other things, forgetting their own duties. They should ensure at the end of the legal year, they need to rethink and say, I have to forego the holiday, but I must discharge my duty as a judge. That sense of duty is taught by our Bharatiya Gyan Parampara. In ancient legal system, delayed justice was considered most dangerous to the nation or the state. Justice delayed is justice denied was the maxim which was well known to the jurists of ancient India, not a modern concept. They say delay in deciding cases is tantamount to denial of justice. Dharmapati, literature, death of justice. It amounts to death of justice. In a soliloquy in Shakespeare's play Hamlet, law's delay is condemned and the protagonist ponders over whether to be or not to be. The phrase goes, oppressor's wrong, proud man's contumely, the pangs of despised love, the law delay. Therefore, the delay of the law is considered to be one of the primary evils in life during those periods. Now it is no. One of the luxury which is enjoyed by our juries. Discreet and unscrupulous adjournments are one of the reasons for delay in the administration of justice. Ancient Indian jurists had laid down strict rules regarding adjournments or delay. You can find it in my Judicial Accountability Bill. For deciding disputes, a time limit was prescribed which had the tendency to discourage futile litigation. And Manu has very well described how the delay results in failure of justice. Rule in conformity with the high tradition of Indian thought, according to which investigation of truth is the highest pursuit at that particular time. That was our legacy. K.P. Jaswal is perfectly right when he says that the high traditions of Hindu judiciary are worthy of being followed in any age, any civilization, any country. This is what we are proud of it. I brought in another as a law minister, national litigation policy. Again in the year 2010, we adopted a policy to transform government into an efficient and responsible litigants. I don't want to deal much on that, but I go forward. In fact, there are tributes paid by modern jurists to the jurists of ancient India. The development of the adjective law was evidence that the administration of justice in ancient India attracted the full attention of jurists in ancient India. Justice was according to law and in consonance with the principle of jurisprudence and accepted social norms. Every point in case was subjected to close scrutiny. Do we have that kind of a scrutiny now? In any given adjudication? No. That is why people suffer, the nation suffers. It shows the high character of these early law books. Development of society and the litigation before it made the need for the rules for determining the truth in conformity with Indian view of life, which aims to investigate the truth. Investigation of truth is the main theme of Bharatiya Gyan Parampara. Is there any? Are we aiming at that? Investigation of the truth? If there is no investigation of truth, how do you find the truth? Or how do you find the dharma? Therefore, the rules of evidence, which have their basis in the rules of philosophy, were much advanced in nature, extent than their counterpart in the most developed legal systems. That is why we are proud of our India and our legacy. The remark that even pleadings with the extensive technical rules from modern Europe have not managed to surpass the Indian rules of proceedings made by Jaiswal are perfectly justified. 3 generations of undisturbed possession is superior to documents which are in turn superior to witnesses and witnesses who are superior to interference or circumstantial evidence. This is the law which is envisaged by Katyayana. It is analogous to the modern concept of constructive res judicata incorporated in explanation 4th in section 11 of the Code of Civil Procedure. 1908. So these are all many things which I can speak, but I don't want to take out your time because you have a big agenda before you. But I must tell you that, though these Prati writers required the production of document as primary evidence, but in exceptional cases, they allowed secondary evidence also to prevail. It was not documents itself are not sacrosanct. Documents as means of proof in ancient India. India, as assumed, very much important. Therefore, the rules were enacted in the Dharmashastras to ascertain their genuineness, and extreme penalties by way of deaths were prescribed for fabricating the document at that time in the Indian judiciary. Ancient Indian judiciary was much advanced in the field of administration of justice. Advanced of the judicial system lies in the policy of regulating punishment. And one more thing I like to emphasize that capital punishment was not prescribed in the ancient judiciary. Now the entire international legal faculty is discussing on that. We have already settled that no capital punishment is to be given in our legal system. And and this is the time when we have to relook on capital punishments. Convenient substitute or alternative for capital punishment was prescribed and practiced in our legal system. In fact, the Vaisheshika Sutra, Dharma, was also seen as a synonymous to the entire teachings of Buddha in the sacred books of Buddhists. These are all some of the things which I would like to say that. In fact, even the principles of interpretation of Upanishads, they speak about Dharma and also the law. I have also quoted on doctrine of two sources, two contrasting and opposed influences, how it is settled. Ultimately, the law is settled. The history of natural law, if actually reflected in any law of the world, in fact, it is in India that is applied. With the change in social, political, ethical, and the economic views of the society, idea about natural law or criterion for justice also changes. The law is the right reason in agreement with the nature. This is the principles of our law. And I must tell you that, many a times, judgments are given on only technical grounds. I remember when I was a law minister, I can give one example. There was a brutal murder in Bombay. What happened? For want of evidence, he was acquitted in lower court, district court, sessions court, acquitted in the high court. Matter came up before Supreme Court. There was a big galata in the newspapers and all it came. That, he will again be acquitted by the Supreme Court of India. Because the accused happened to come from the influential family. Ultimately, what happened, I met that particular judge who was hearing, that Supreme Court judge. I don't want to name him. I met him, I gave him an example. In front of Madras High Court, there is a statue of Chola, king. And I reminded the judge, have you seen that statue before the Madras High Court? And that King Chola, he had kept a bell in front of his palace. Anybody aggrieved, story goes, he can ring the bell. And his son, that king's son, he ran over a calf. That cow started ringing the bell. And king came out. Then he asked the others, what happened? Because the cow was killed because of the negligence of his son. Then he said, the son will have to be punished similar way where he has to be killed. That is why the statue of Chola king is found in the front door of Madras High Court. Then the judge, I met him for a dinner later. Moili, you betrayed me. What did I do? Did I influence you on your judgment? I only narrated a story. Then so that your conscience can be pricked. He said, yes, my conscience pricked. I went to the evidence, and in fact, the punishment was given to the accused, justice was done. I said, that is why, as a law minister, I never wanted to influence your judgment, and ultimately, the justice was done. That is Manuvidhi Cholan. Manuvidhi Cholan, this is the story. So this is what is required. In fact, synthesis has to be made in which all persons are to live respectfully. And if we do not do away with the causes which created outcast in our social system, we retain the seed of disruption and ruin in our chances of eventual survival. This is what needs to be done. And go back to our law. That is the origin which can inspire us with a proper justice. And my book, Bharatiya Gyan Parampara, in detail deals with this, giving instances. And in fact, while reading it, because sometimes, for example, Manu, he has been mistaken because he is the one person who gave a secular law, but at the same time, people say he only propagated Varnashrama Dharma. No. We need to read in a right perspective the legacy, and in fact, the time has come when we need to again come back, relook on our law, justice administration. That is how we can get real justice in our day-to-day life. With this, I conclude, and thank you very much for the time given to me. And it is necessary that, we should be proud of our legacy and march forward in justice system. Thank you very much. Oath is to be given now or what?
Thank you very much, sir, for that insightful address and for sharing with us from your wealth of knowledge, wisdom, and expertise. Thank you very much. We will now move on to the administration of the Law Day Oath. For this, all the audience members would have received the Law Day Oath as you entered in. I request you to please take that out. I request all the audience members, let us stand for the administration of the Law Day Oath. I would like to invite once again Honorable Dr. M. Veerappa Moily, sir, to administer the Law Day Oath.
I take oath and thereby pledge that I shall at all times abide by the Constitution, respect its ideals and institutions, and uphold the human rights of all my fellow beings. Recognizing that rule of law is the foundation of our constitution system, I shall forever renounce the use of violence, bribery, and corruption, appeal to religious passions, and promotion of religious and ethnic hatred. I shall ceaselessly promote harmony, and the spirit of brotherhood. Uphold the dignity and equality of men and women, and to the limit of my economic capacity, provide help to the disabled and deprived. I have resolved that as an individual, either citizen or resident, I shall not compromise with the terrorism and bravely fight in with all my resources until it is wholly exterminated and world over and peace are fully restored. My contempt for terrorists extends to their collaborators, groups or governments that finance them, harbor them, or in any manner abet their evil designs. I shall fearlessly expose records of the Constitution and breakers of the law, refuse to lend them respectability or prestige, insist on vigorous and impartial enforcement of law against even the high and mighty, and strive to promote justice, social, economic, and political. So help me God. Thank you very much.
Thank you very much, sir. You may be seated. Due to the paucity of time, we have collected a few questions that I will be reading out, sir, for our question and answer session. One of the questions was that the Nyaya system places a strong emphasis on logical argumentation and debate. How can the principles of Nyaya be applied in contemporary legal education and practice to enhance critical thinking skills and promote rigorous analysis of legal issues?
In the Merchant of Venice story, Shylock wanted the blood. And a pound of flesh. Then, the judge said, can you take out blood without a pound of flesh? Or you can find out a pound of flesh without shedding the blood. This is what is happening. We have seen, I also handled a number of cases where, ultimately man is hurt, the society is hurt, the entire nation is hurt by depending only on logic. The argument of logic alone is not the instrumentality of arriving at justice. That is why our justice system in India, legacy, is a truth which is very much along with the dharma. And dharma is not only the wisdom, but it's also the truth embodied in the whole gamut of legal system.
Thank you, sir. Another question was, considering the rich philosophical underpinnings of the Nyaya system, how can its insights into concepts such as causality, perception, and inference contribute to a deeper understanding of law and justice in today's complex world?
I gave the example of a Supreme Court judge dealing with a murder case. And if you strictly go by the causality, as when we said, both in the Sessions Court and the High Court, he cannot be punished at all. But it's always a truth which is camouflaged with this kind of a logic and causality. And only when you get into that, finding the truth, the real judgment can be given and really one will get the justice. Justice is not mere logic. Justice is not mere vocabulary or the skill, but is something beyond that.
Thank you, sir. Thank you very much. Due to the paucity of time, we'll just take maybe one more question, sir. How has the Nyaya system...
I will give one example.
Yes, sir.
I was dealing with a case in the lower court, in the municipal court. I started my practice in the, the 7 of the members of the family are beaten black and blue by the landlord. He's a big landlord, estate owner, and he goes to the hospital, government hospital, they don't entertain him. They will not be entertained. He goes to the police officer, he doesn't register a case. Then I file a complaint before the magistrate saying that hospital doesn't entertain me, the police do not entertain me. I thought you will entertain me and give the real justice. And he shed tears, that judge, and issued non-bailable warrant to all the 12 accused. They are the biggest people. That was a big sensation at that time. But the real story is something else. It came for an evidence. That client of mine, who is a tenant, enjoyed the land last 75 years, is a total illiterate. And the lawyer who cross-examined him is an eminent criminal lawyer. I just entered. He went on putting us questions. You have filed a complaint? Yes. You filed a complaint because your lawyer Veerappa Moily asked you to file? Yes. You signed because what he wanted you to sign? Yes. Just imagine my fate. So it's not the mere logic, mere intelligence of a lawyer, but the real justice is that he suffered. He was dispossessed. He was thrown out of his house, thrown out of his holding. Who will give justice to him? I'm telling you, this is how justice system in the country works. That is why our Indian, Bharatiya Gyan Parampara is necessary to give the real justice, not for the intelligence of a lawyer, not for the, vocabulary of a lawyer's word, but the real agony which affects the hearts of everybody.
Thank you, sir. On a related note, there's also a question, what is the role of traditional dispute resolution mechanisms in Indian society and what is their relevance in modern legal practice?
In fact, whatever you feel that, the Evidence Act, it was available. Evidence Act was available. And, principles were laid down. More so in the Buddhist law. It was just available. It was being practiced. But the only question is that it was easier to find the real truth or dharma in the Indian legal system than the modern legal system. Modern legal system goes by only the logic, the argument of a lawyer. If the lawyer is more efficient, he will win the seat. Not that there is a real justice or not. Real justice is only camouflaged by the intelligence of a person or the pleadings which is done today. But earlier justice system, they really went into the real justice and yearning for a justice, hunger for justice. That hunger for justice is never quenched in the modern legal system.
Thank you, sir. Thank you for your insightful and compelling responses to these questions. To deliver the formal vote of thanks, now I would like to invite Dr. Aparajita Mohanty, Deputy Director, Symbiosis Law School, Pune.
Thank you, Professor Lasya. On behalf of management of Symbiosis, Dean and Director, Dr. Sashikala Gurpur, It is my honor and privilege to deliver the vote of thanks for the most prestigious event of Symbiosis Law School Pune, Law Day Oath, Justice Y.V. Chandrachud Memorial Public Lecture 2024. I extend a warm vote of gratitude to Honorable Dr. M. Veerappa Moily sir for consenting to be the chief guest and deliver the memorial public lecture. Sir, your discourse today, reflections on Nyaya Shastra and concept of justice is phenomenal, and we are sure that it has kindled the spirit of inquisition in the young minds to explore Bharatiya Gyan Parampara, which is one of the mandates of NEP 2020. We extend a sincere note of gratitude to our Honorable Chancellor, Professor Dr. S.B. Muzumdar sir, for his constant support, guidance rendered to us and to our law school. As Dr. Gurpur has rightly mentioned, sir, you are the towering personality in the landscape of education, and you have shaped the destiny of millions of students across the years, which has also transcended the national boundaries. Thank you, sir. We are indeed honored with your presence. I thank Shri Shantanu Lamdade, State Coordinator for PRAVAH, for collaborating with us as the knowledge partner. Dr. Sashikala Gurpur has been the guiding force at Symbiosis Law School Pune since 2007. Under her competence, leadership and vision, Symbiosis Law School Pune has strived for excellence consistently. Thank you, ma'am, for your guidance, mentorship, and support rendered to students, faculty, and staff from time to time. I thank the students and faculty for attending the event, which will be followed by Vidhi Manthan in a short while. Thank you, one and all.
Thank you, ma'am. I would now like to request everyone to rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you. We will now break for lunch. I am informed to let the students know that their lunch is arranged at the reception area, the faculty next to the auditorium. The dignitaries and the resource persons for the symposium will be in the conference room. All the audience members are instructed that after lunch we will be continuing with the symposium, so you are instructed to be back in this hall by 2 o'clock.
Recording stopped.
Students, you are requested to remain silent as we will be commencing with the symposium. Good afternoon, students.
Recording in progress.
I'll request all the students to please settle down. Welcome back, and we will continue with our symposium on Vidhi Manthan, Bharatiya Gyan Parampara in Law and Justice, organized in collaboration with PRAVAH NGO. The Indian knowledge systems, as according to the Ministry of Education, comprise of Jnana, Vigyan and Jivan Darshan that have evolved out of experience, observation, experimentation and rigorous analysis. This tradition of validating and putting into practice has impacted our education, arts, administration, law, justice, health, manufacturing and commerce. There is no better introduction to this symposium apart from the prelude that was already given in our first part of the day's celebrations of the Law Day. I would now like to invite the resource persons of the first plenary session onto the dais. Firstly, I will invite Mr. Pratik Thatrak, coordinator from PRAVAH, Dr. Atmaram Shelke and Dr. Ashutosh Panchbai, faculty, Symbiosis Law School, Pune. Professor Aruna Sampath, former faculty of History, Symbiosis Law School, Pune. I expect the equal amount of enthusiasm in inviting all our resource persons. And we have a resource person joining us online as well, Mr. Shravant Arya Tandra, advocate and alumni of Symbiosis Law School, Pune. The resource persons may be seated. Thank you. To commence with the opening remarks, let me welcome and introduce Mr. Prateek Dhatrak. Mr. Prateek Dhatrak has successfully completed his MCom, CA, CS and LLB qualifications. He has secured 9th rank in All India Merit in CA exams. After gaining 1 year of corporate experience at Bharat Petroleum Corporation Limited, he started his finance and tax consultancy. Since 2018, he has been serving full-time as a social worker in various social organizations. He has worked extensively for 5 years in Kolhapur district, overseeing service projects, and is currently dedicated to student welfare initiatives within educational institutions through forums like PRAVAH. I would like to invite Mr. Prateek Dhatrak to deliver his opening remarks.
Good afternoon, and I understand the responsibility that this panel has to keep you awake after this heavy lunch. The one sign which we can clearly understand that when we say Bharat was a glorious country, and in this glorious country, one of the sign was that foreign scholars used to come here to take education, to take scholarship at universities like Takshashila, Nalanda. So one of the objectives of forums like PRAVAH is to rebuild this scholarship, rebuild this educational vigor through academic discussions, such workshops, such conferences, and rebuild what we have lost. As it is said in Rigveda, Ano Bhadra Krato Yantu Vishwataha. That is, let all the noble thoughts come from all the direction. And therefore, we are not only restricted to what was there in this country, only Bharatiya Gyan. But we have always believed that let knowledge flow from all the directions. But we need to add one more thing. This Rigveda also says, Ano Bhadra. So what is Bhadra, what is Abhadra? That was the taste. So what is good for us, what is best suited for our society, our culture, our civilization, that knowledge was welcome, and it was welcome from all the directions. As one of the great philosophers and greatest thinker of his time, Pandit Deendayal Upadhyaya said, whatever we have, whatever knowledge that we have to make that knowledge yuganukul. That it should be time and tested to the times in which we are living, and it should be accepted globally. And whatever is good is there outside, which is not in our country, not in Bharat, we should accept that knowledge also, and we should make it Deshanukul. So knowledge always has to pass these two tests of Yuganukul and Deshanukul. And from all this knowledge, what we have to achieve is again very well simplified by Yogi Arvinda. Yogi Arvinda had said, Atit ka gaurav, that is glory of the past. Vartaman ki pida, that is problems of present, contemporary. Or bhavishya ka swapna, that is tomorrow's, that is futuristic approach. If these three things are there in youth, that country can prosper, that country can be developed. And therefore he looked up to the youth that there should be balance between Atit ka gaurav, Vartaman ki pida and Bhavishya ka swapna. And therefore my humble appeal to all the students, why we are discussing this year, what is the relevance of Bharatiya Gyan for today's students. Is it there in our syllabus? Will it going to be help? Will it be in addition to my internships, scholarships of my job? We should not think in this limited perspective, because we are the makers of tomorrow's future. And therefore there are a lot of problems which our generation has to solve. So there are many problems like climate change, participation of women workforce in employment, n number of problems are there. And at all the forums, right from global forums, all are discussing these forums. And all the countries are looking up to Bharat that what solutions this country can give to this global problems, global scenarios. Because we had that approach of managing both the paradoxes. So we were for the global development also, but at the time we were for spiritual development also. So these both paradoxes were managed at a time only in country like Bharat. So all the eyes today are set up towards us that what solutions we'll be providing through our knowledge systems. And therefore why these discussions, why this Bharatiya Gyan Parampara is relevant, is to solve tomorrow's problem, is to solve today's problem and build a future which in our Symbiosis motto also we have said, Vasudhaiva Kutumbakam. And therefore, I request all the students to participate in these 2 plenary sessions with this open mind. What your discussions we are going to have. So this is just the beginning of these discussions to raise your inquisitiveness. More has to be done in these areas. Not all the thoughts which are there are developed today, but I request all of you to engage in these intellectual discussions and participate in these 2 plenary sessions. Thank you.
Thank you very much, sir. I would now like to request Mr. Pratik Dhatrak to felicitate the remaining resource persons of the panel. I would like for you to felicitate Professor Aruna Sampath, former Faculty of History, Symbiosis Law School, Pune. I request you to now felicitate Dr. Atmaram Shelke, Associate Professor, Symbiosis Law School, Pune. I request you to now felicitate Dr. Ashutosh Panchpai, Assistant Professor, Symbiosis Law School, Pune. I invite Dr. Aparajita Mohanty ma'am to kindly felicitate Mr. Pratik Dhatrak. We also warmly welcome the online participation of Mr. Shravantarya Tandra. Thank you very much for being with us here, sir.
Thank you.
To commence with the session, I would like to introduce Dr. Atmaram Shelke and Dr. Ashutosh Panchpai to the House. Dr. Atmaram Shelke is an Associate Professor, Symbiosis Law School, Pune. He is a PhD in Intellectual Property Rights Violation in Cyberspace and is qualified as an Associate Professor of Law. He's a specialist in IPR violations, constitutional law, in administrative law, research methodology, and e-justice. The fields of his research interests are various. He has more than 13 years of teaching experience and has taught learners of BA, BBA, LLB honors, master's degree, PhD coursework, and EU value-added courses. He's also involved in teaching of European students visiting India under the umbrella of Symbiosis. He has a keen interest in research and understanding of various methods of knowledge. In his thesis, he has compared a part of the inquisitorial system with the adversarial system. As a part of his graduation, BA, he had studied Prakrit, an Indian system of knowledge. Dr. Ashutosh Panchpai is an assistant professor at Symbiosis Law School, Pune, and teaching jurisprudence, law of contracts, judicial process, and interpretation of statutes. He's a member of the academic committee, Symbiosis Law School, Pune, and also member of Community Legal Care Center and Gender Champions Cell. He's working on innovative interventions in synchronous and asynchronous mode of teaching learning process and has evolved creative tools for online learning. He's a part of the core faculty of EU e-Justice course and also a member of the core committee for content creation in MOOCs at Symbiosis Law School, Pune. He has completed his PhD from RTM Nagpur University on the topic Contribution of Appellate Body in the Development of WTO Jurisprudence. I invite both of them to speak on the construction of knowledge, how it is different from conventional material perceptions of Akanksha, Mimansa, interpretation of Bharatiya Gyan Parampara.
Thank you, ma'am. Respected Aruna Sampath, madam, Pratik sir, my colleague Dr. Ashutosh, dear faculty member and dignitaries of the dais and dear learners. Today we are going to speak about two methods, that is Akanksha method. Ashutosh sir is going to cover Akanksha method. I am going to cover introduction of Mimansa and how it is different from the existing system. What is being covered under existing system, that is also highlighted. Now these two methods are dealing with three different things. One, it is dealing with understanding of the existing knowledge. Now understanding of existing knowledge for Mimansa is divided in two parts. One, absolute knowledge, it is not questionable or it is not subject to additional proof. That is the meaning of absolute knowledge. So sun is there, it is exists and that is absolute knowledge. No additional proof can be required. So similarly Vedas are treated as absolute knowledge for the Mimansa methodology. And another in case of understanding is peculiar knowledge or knowledge subject to condition. So if there is a condition, then only that knowledge will be exist, or in order to have existence of the knowledge, some condition need to be fulfilled. So they have given, the authors have given example of the smoke. Unless and until there is a fire, there is no question of the smoke. That example, old example they have given. So that is peculiar knowledge or subjective knowledge, which sir also was talking about. Second is, it deals with validation or affirmation of the knowledge. Right now also as part of research methodology, we are studying this partially, but it is elaborated like anything in the ancient Indian legal system. So in case of validation of knowledge, existing knowledge can be validated with help of additional proof or with help of additional explanation, or knowledge demand the explanation. Normally it is known as problem. So your problem, some explanation. In order to validate, your perception about that is required. Third level, which is little highest level, is creation of knowledge. Creation of knowledge, they have divided in two parts in Mimansa. One is creation of absolute knowledge that may lead to your patent. Innovation will happen. And it may be extension of the existing knowledge. There also patent may be granted or innovation may be there. Now this Mimansa is dealing with two things while dealing with three different levels: understanding, validation of knowledge, and creation of knowledge. So it is dealing with the source of knowledge. Somewhere source of knowledge is very important, and that is what is covered under Indian Evidence Act partially, or common law system partially, and partially it is found in adverse inquisitorial system also. Second, it deals with the process, like in dying declaration. Not only source, but also process is required or important. Or natural justice principle, not only source, but also process is required. So all these things are elaborated well in 900 year back, etc. So if you see the word Mimansa, it means solution of the problem by reflection or critical examination. So Mimansa, whenever this word is used, and there are 5 subcategories, I am going to introduce in brief. It means examination of the problem by reflecting on that or by critical thinking. So they were talking about critical thinking that time. Right now it is part of the syllabus partially, not fully. So that time also Indian legal system was talking about, or knowledge system was talking about critical thinking. Now there are 4 major author or main author on the Mimansa. One is Jamini, who is the main author, who has written more than 9,000 sutras, which is known as Jamini Sutra, and lot of explanation on each thing out of 5. So entire book is related to 5 subpart, lot of detailed explanation is given. Partially, maybe 1 or 2% of that is found under Indian Evidence Act. We'll go to that examples later on. And then there is Sabra Swami who has written commentary on that, which is known as Bhashya. He has not created anything, he has written additional explanation, and therefore it is known as Bhashya or commentary. Apart from that, there are two schools. One is Bhatta school, and another is Prabhakara school, which is written by two different authors. And there is slight difference between two. Like jurisprudence we study right now, and difference here and there can be found. Now this Mimansa recognizes two kind of knowledge. One is immediate knowledge, second is mediate knowledge. Now in case of immediate knowledge, knowledge which is directly pursued by the sense is considered, along with the mind. Now in the existing philosophy, there is a lesser emphasis on the mind, and there is a direct emphasis on the things which are seen, known as direct evidence, etc. But direct evidence is considered or pursued differently by different people. Our law does not talk about that. Our Indian Evidence Act does not deal with respect to that. Examination, cross-examination, re-examination is found. But different people will deal with the same thing differently. That deliberation is not found, which is found as part of Mimansa. And second is mediate, which is not pursued by the senses. In second category, there are 5 subparts. One is comparison. It is known as Upamana. Comparison right now also, in your syllabus also, lot of comparative analysis is seen. Nyaya is also deals with comparison. And that time, it was deliberated well. Lot of explanation is given. Right now, if you go to the library, try to find out the books on comparative law or comparison per se, why to compare, etc. Little bit explanation, why and how and where is given. Whereas in our old system, deliberate explanation is given. Nyaya is dealing with first kind of comparison, which is known as application in research methodology or in law. Like here, IRAC system you applied. So existing things you have to pick up and you have to apply. For the purpose of Nyaya and comparison, both things shall be there. The explanation of two things shall be there, and then thing is found, you can give you can apply that knowledge to the thing. They have given example of the ox, which is known, and description of ox is known, and wild cow or any other cow which is not known, but description is known. So description of both is known, and you are applying description of one to another. It is considered as comparison in Nyaya. Whereas in Mimansa, they have gone beyond that. You are aware about one thing, or description of one thing like cow, and you are applying it to wild animal, another animal. So in case of Nyaya, description already given or exists is important. In case of Mimansa, author is important, who is going to add something new in the knowledge. So addition of knowledge will happen in case of comparison. Now if you think right now also, lot of research is done with help of comparative study, and there are two kinds. You are having description of systems or knowledge, like we are acquisitorial system, inquisitorial system, and you know what are the parameter or what is being considered or what is there in both systems. And third tribal system is given to you, and you are going to compare whether it follows adversarial system or whether it follows the inquisitorial system. Now that is comparison is being covered in the Nyaya. Whereas in case of Mimansa, they have gone beyond that, and they said if you know one thing, you can compare that with another thing. Common point can be jotted down, additional point can be jotted down, the advantages and disadvantages can be pointed by the author. So author is important. So you know our existing system, you are going to compare that Philippine system or tribal system for that purpose. Or any particular way of dealing with the justice, you are going to compare with another. That is being covered under the Mimansa, which is part of the Mimansa. So there is slight difference between Nyaya system and Mimansa system. Nyaya is narrow in that sense. Second part or second subtype which is covered in the Mimansa is Shabda, or it is something which is written or something which is spoken. So oral testimony or written testimony is covered under the Shabda. So this is also divided in two parts. Shabda or testimony which is personal, Shabda or testimony which is impersonal. Veda was treated by them as example which is impersonal, not created by human being, which is absolute knowledge. There is no question of challenging that knowledge. In law or Indian Evidence Act, it is not as conclusive proof. There is our absolute proof. There is no question of challenging that. Or absolute evidence, like DNA. There is no question of challenging that. So that time they have given lot of description with respect to this, which is not found in today's system. Second is personal, and that is also covered under present system. Personal is divided in three parts by them. One, which is reliable knowledge. Second, which is less reliable knowledge. Third, which is non-reliable knowledge. Here also, reliable knowledge is indirectly found under Indian Evidence Act, like Section 60. Section 60 deals with hearsay evidence, which is not admitted. It means it is loose knowledge, non-reliable knowledge. Whereas, according to Section 4, something may be presumed which is less reliable. Something shall be presumed which is more reliable. So right now also that categorization is found. But if you open the commentary, any commentary on Indian Evidence Act, little bit explanation is given. Whereas in our old system, very detailed example with help of lot of examples is given. Explanation with help of example is given. Now if you open our law, they are specific with respect to certain things, like dying declaration. But what is philosophy behind that? What is principle behind that? Whether it can be extended to another situation, all these things are not found under any section of Indian Evidence Act, where including 32, etc., whereas it is found over there. With respect to written things, spoken thing also, who is speaking, whether it is normal person, whether it is expert, that is being considered over there. Right now also statement made or hearsay things are not considered, whereas in case of hearsay, the knowledge of the expert or testimony of the expert is considered. So they were talking about that at that time also in detail. In case of books, etc., or other sources of knowledge, in case of written thing, again divided as a thing which is authority, non-authority, which is found right now also. Some books are declared as authority. What it means, other side has to prove that knowledge given, like Sirvai, knowledge given in that book is wrong, knowledge given in that book is untrue. That deliberation is found in Mimansa at that time. Third part of the Mimansa, fourth part I think, is understanding Mimansa or creating knowledge with help of postulation. It is known as Arthapati, with help of postulation. Now for the purpose of postulation, you are having effect, but you don't know why that is happening. It is, in research language, it is known as exploratory research. And there you are drawing the assumption. Lot of assumptions are drawn. And they have taken, authors have taken small or simple example that somebody is continuously on the fast and being fat also or growing also. There can be two explanations to that. One, the person may have some hereditary problem or medical problem for that purpose. Two, person is eating in the night. Same thing with respect to your grade also, and lot of self-studies provided. So you have to study, and you have seen your friend which is not studying in the day. There can be assumption behind that. That person is studying in night, or person is studying somewhere where you are not able to observe. So there is effect, and you want to give explanation to that, known as postulation. So assumptions are drawn with respect to that. Cyber crimes are increasing. Why it is increasing, you want to find out. So it is part of exploratory research, which is deliberated well at that time, but unfortunately it is not part of the study. It is not considered as part of the syllabus in the creation of knowledge, that is methodology, including legal research methodology and in legal system also. A last part of Mimansa is non-perception, Anupala Baddha, non-perception, things which are not pursued. And in that subcategories are that. Because in postulation, you must have seen, you are able to see the effect, but you are not able to see the cause. In perception, sometimes effect may not be there, or they have divided it in further category. The example which is found in the commentary is that you went to somebody's house, it is locked from outside, there may be some assumption with respect to that. One person, your friend must have gone outside, that may be assumption. Or he or she is sleeping inside, somebody has locked it from outside, that is second assumption. Now why first shall be relied more, why second shall be relied more, why third shall be relied more, all these description they have given, which is not found in existing knowledge creation system. So it is more reliable as compared to existing system, but unfortunately it is not studied well. It is found partially under Indian Evidence Act, like section 460, 45, 32, we have discussed in declaration, etc. So this methodology that is known as Mimansa, and there are books written on Mimansa or these 5 categories. So on everything you can see at least one chapter. So if you open comparison part, at least inductive deductive methodology is there in existing system of creation of knowledge. But that time also they have given lot of explanation or deliberation with respect to that has been done, which is not found in existing system. So that was from my side. I'll request Ashutosh sir to talk about Akansha method. Thank you.
Thank you, sir. Respected dignitaries, on and off the dais, my beloved students, the divinity in me salutes the divinity in you all. And topic which is actually I'm going to embark upon, which is given to me, that's construction of Indian knowledge system and how it is different from Western approaches when it comes to construction of knowledge. So Indian knowledge system, which is actually based, epistemologically we can say, on Vedic and Upanishadic philosophy before coming of the Darshanas, okay? So I'm taking you back before the Darshanikas where Sir started. So let us go back to the Vedas, okay, or Upanishadic philosophy. And let me start with that fundamental question, or that aboriginal curiosity which is in everyone's mind. Let it be innocent curiosity when we look up at the darkest of the dark sky, which is galloped with the full of stars in it. Don't you come across that curiosity? I mean, that is original quest to know about the cosmos, the cosmics, and the entities, the interstellar realities. And that is the curiosity inside which has driven. And the fundamental question, that question is, I will start rather this discourse with a debate, and then that difference you can better realize or internalize in your own. And that debatable question is, when Vedas are called as apaurushayas, please listen to the question very well. When I say Vedas, they are apaurushayas. This is what that Vedic testimony say. They are not manly creation, or they are not created by human beings. They are the apaurushayas. And now it is counter-argued by Professor Jinsiwala, who said that, see, Vedas are in language. And language is human creation. So it is a mismatch. It is an antithesis to what you are saying. Either they can be apaurushaya, or they can be paurushaya because they are in language, and language is human creation. So this was sorted out by Lokmanya Bal Gangadhar Tilak. You can find references in his Arctic home in the that Arctic home in the Vedas also. In the prelogue itself, which is testimonied by the Max Muller also, he says that, see, the mystery is resolved like this, that, see, I agree Vedas are in the language, but they are realized, they are perceived by the sages, those monks who have attained that homogeneity with the God. So by meditation, by constant contemplation and those spiritual practices, there is sublimation and that spiritual enlightenment, that dualism has ceased to exist and they have become thou. So the knowledge, the knower, and the subject matter of that is knowledge. So there is perfect homogeneity. And in that spiritual sublimation where the seeker is seeing himself as the God himself, so that incarnation, that manifestation of the divinity percolates in him, and that doerness disappears, that vanishes the ego and the duality. So in that stage of oneness, those Vedas are taught to the sages. So that's why they are apaurushayas. And this is what the unique difference in the Occidentals and the Orientals philosophy, where Occidentals or Western approaches are plenarily, dryly dependent on the logical scrutiny of the knowledge. Logical scrutiny. Based on that intellect, they are inquiring into that. But let me reiterate here, the subject matter of the contemplation Veda is incredible. It is infinite, and that's God. So that's why it is said that Vedic and Upanishadic philosophy, it is not merely a body of knowledge like Western logical science. It is a system of alps raising over one another. It's a system of the knowledge. It's infinite. So when subject matter of Veda, that itself is infinite, Vedas are bound to be infinite in their content, in its approach, and I will use the Hindi word Swarupa. Okay, that's why they are infinite in their approach. So many of the things you will find that, so Western approach is actually from inward to outward. They are going outward for material pursuits of their sciences, whereas spiritual pursuits are there. The very aspiration behind Vedic and Upanishadic philosophy, be it any dogma, be it any tenet, be it any gospel, across all the Vedas, if you can find summaries you can come up with on the surface, like Tattvamasi, Sarvam Khalvidam Brahma, Aham Brahmasmi, Shivoham, that while I mean, you can find it out. So that aspiration behind the knowledge is spiritual. So that aspiration being so spiritual, one more striking difference between Western and Oriental wisdom, I will tell you when it comes to philosophy. See, that Western approach tries to know the thing at onset. However, unlike that, the Oriental wisdom, that Vedic and Upanishadic philosophy, and even darshanas also, in all its pursuit, be it heterodoxies or even orthodoxies also, their approach is spiritual, highly spiritual. So, I'm revealing that what I read, and I think, correct. So, before knowing the creation, let us know the Creator. I repeated what I said. Before knowing the creation, let us praise the Creator. And that's why in Nasadiya Sukta, which is a part of Rigveda, it begins with aboriginal curiosity. You might have heard that hymn from the Rigveda, which is very famous. You are raised perhaps in that culture when on DD1 there used to be a serial. And it was actually the opening track of the serial and closing track of serial was based on Nasadiya Sukta of Rigveda, and the closing track was based on Hiranyagarbha Sukta of Rigveda. I'll name that serial. It was Bharatiya Gyan, which is based on Discovery of India, a book by Jawaharlal Nehru. And Hindi narratives which runs like that. पृथ्वी के पहले सत नहीं था, असत भी नहीं, अंतरिक्ष भी नहीं, आसमान भी नहीं था, छुपा क्या था, कहाँ अगम में किसको पता था. So these are the original quests which actually they are inquiring into. So before knowing the creation, let us pray to the Creator, and with His grace, there will be internalization, that sublimation within, and we will know perhaps, we can decode perhaps each and every mystery which is supposed. And I will tell you what Kant, that Kant actually, he has created very much in the Western philosophy, and it is said that all those later Western philosophers, they couldn't create anything new. They are nothing but the footnotes on the original dialogues of Kant. That Kant I'm talking about, recalling it. He says that knowledge cannot be created. I mean, when it comes to the Indian notion of knowledge, one more striking difference is that Shankaracharya, in Madhavacharya, so follows it in his Bhashya, he says that Yathartha Dhyana Lakshanam, which the nirvikalpa yathartha dhyana lakshanam. So it is not only knowledge which is contemplated, but two ultimate attributes of the knowledge are, that is nirvikalpa and yathartha, as it is. Say for example, I'm talking, I will quote that. He was Heraclitus, one of the Dukkhavadi, okay, that Miserian occult of philosophers, okay, who believes in that everything is miser, it is not perpetual, it's temporal, that credibility that world gives you, the clappings that you are giving, that respect that you are giving, everything is miserable, that is not going to last long, it is momentary, and that's why it's not real. But see the irony of Western approach. He used to make cuttings of the newspaper when his discourses are actually published as a news. His cuttings, his newspaper items, his photographs which are published in the newspaper, he used to make a collection of them. This is irony, this is paradox, this is actually self-contradiction. Unlike that, Indian approach contemplates, and it strongly contemplates. When you are saying Brahmasmi, you should not fear death. When you are saying Shiva you are teaching it to your disciple, you should confront that reality as death is not the end of life, but is ultimate fulfillment and completion of your existence. It's just like hibernation between life and death, isn't it? So that conviction should come inside. And now I will tell you the conclusion where I am. So the difference between Indian and that Western approach, when it comes to the approach to the construction of knowledge, ours is little spiritual, the aspiration is spiritual. Even in Buddhist philosophy also, when they talk of nirvana and all those things, the aspiration is freedom from the bondage which is driven by the trishna, and that is equally philosophical. The only difference is that here it is called as moksha and there it is called as nirvana, but ultimately their aspirations are somewhat spiritual in nature. On the contrary, Western approach is little material, and the tenets and the drivers of the Western inquiry, they are equally materialistic, and the difference, that's why this is Western approach is logical in approach, and our approach of Vedic and Upanishadic philosophy, it is intuitional, pratibhatmak. Okay, so that cannot be learned, that cannot be taught. Through intuition, through intense meditation, through practices of all your spiritual cults, you can actually know that. Okay, so this is the difference between Occidental and Oriental notions when it comes to that aspiration towards the philosophy. So this was the first component which was given to me. Second is that Akanksha method and how it is how that can be helpful in the interpretation of knowledge under Indian knowledge system. So every one of us actually know Akanksha method. We use it in teaching also. So the Socratic method, which is question driven, where teacher asks the question to the students. Juxtaposition to that, in Akanksha method, it is the curiosity of the student which drives away. Okay, that is the aspiration, that is curiosity of the student, which enables the teacher to tell him, and that is the method of acquiring the knowledge, and that's why we are studying it in the symposium. Okay, that Akanksha, how it is important method. So one of the classic illustration of Akanksha you can also think of, where student is asking question to the teacher. That is the curiosity of the student which is enabling him to acquire the knowledge. And a classic example is Bhagavad Gita, okay, where that Arjuna, when found in that dilemma, okay, putting down his bows and arrow, he is in Confucius state of mind, what to do, how to go with war against those who are my aptas and swakiyas. So now question after question after question is being put by him, and he is a teacher like Krishna. Okay, he is not going any question undone with, he is responding with equal vigor, with equal zeal, every question to the extent possible. And if he thinks that my intellectual pursuits are not going at all to satiate his quench or to satisfy his curiosity, then he is showing the Virat Rupa Darshana also. And at the end, he convinces him. So by giving all those inputs, that student-driven process, I am curious, I am akankshita, to get that particular knowledge, oh Krishna, you give it to me. That's why in Hindi it is said that भगवान कृष्ण ने गीता कही कम थी और अर्जुन ने कहलवाई जाता थी. कहलवाई, that itself connotes that it is something which is actually student driven process, and that doesn't work at the end in Akanksha. It requires absolute surrenderance to the teacher, absolute surrenderance, and this is contemplated and inbuilt feature of the Akanksha method. Without that surrenderance, without that refuge, you cannot have, or you cannot qualify to percolate with that divine knowledge. And that's why perhaps at the end, one after one, question after question, satiating all the quench, that academic quench, the intellectual quench, still he is in a sambrama, and that doubt is not gone. Then only one sentence is said, and that wipes out everything. And that sentence is that let that doubt, okay, sarvavadan parityajya mamekam sharanam vraja. Give up all these doubts and surrender to me. Now I will handle everything. So that is the thing which works. So this method is so popular in Indian wisdom. You will find that creation of the many of the Upanishadic text, which is post-darshana creation of the literature. Okay, so many of the Upanishadic text, you will find, Pauranic text particularly, you will find based on the Akanksha method. Say for example, Ashtavakra Gita, a classic illustration. Entire Adhyatma Ramayana is based on that. It begins in the Balakanda with very first question of Parvati, which says that Yajnatum ichham tavarama tattvam purana kinapa vichoditahum bhaktum rahasyam paramam nigudam. So if that Rama is Brahma actually, then why he is crying like a child when in absence of Sita? So in answer of that, the Mahadeva answers, so Danyasi Bhaktasi Paramatmanastam Yajnatum Ichham Tavaram Tattvam Purana Kinapa Vichoditaham Vaktum Rahasyam Paramam Nigudam. I will tell you that secret, and one after one, the Adhyayas of Adhyatma Ramayana, they are created. Gargi Maitri Samvad is one of the classic illustration of that. Bhaskaracharya Gargi Samvad. So too many things you will find their creation of the Akanksha method itself. And lastly, I am almost on the tail end. I am also reminded to wind it up. Okay. So quickly, so sir has given the reference to the means of the knowledge. So these means of knowledge aid and assist in the interpretation also. In interpretation also. Say for example, if I ask you that why we call it Triassic age or Jurassic age, why don't we call it a Jurassic culture or Triassic culture, civilization? Animals don't have civilization, it's only mankind. And because of the knowledge, means of knowledge that discussed by the sir, that is actually a attribute of human being, which is intellectual, shabdas. So we actually store the knowledge. We actually not only we create the knowledge, but we store the knowledge, and shabda is the probable and most powerful mean of interpretation. So we are almost on the tail end, where the shabdas, that potent medium and instrument of the interpretation, where we have stored knowledge and handed it over to the coming ages. Not only created it, but it has become a potent medium to pass it on to the coming generation. And ages to come, it will be transcending, it will be getting passed on. So that's why all those things, they are very much important, very much material here. And there are certain things actually, I wanted to reflect on the critical thing. Lastly, I will tell you how it helps in the interpretation of the knowledge system. Say for example, after Darshanikas, there is one I mean, in Apohavada also, in Buddhism, you might be aware of that Apohavada, which Lakshana, okay, Lakshana means what Sir has told you just now. Lakshana means the definition. But it begins the aboriginal inquiry with a fundamental question, what is the definition of the definition? This is what I use actually in my approach in the class, definition of the definition. They can tell you Lakshana, this is definition of so many things. But what if the definition of the definition itself? Isn't it? So that's why the Lakshana, when it comes to that particular approach, you will find that Apohavada says that cow is not cow because of its universal cowness. Cow is cow because it is not dog, it is not buffalo or something different from others. So cow is cow because not because of universal cowness, but because it is distinct from other things. That's why similar approach you find in contemporary legal studies also. Isn't it? That movable property is a property which is not an immovable property. Is there any sense which makes it? Isn't it? Company law defines in its approach that public company is a company which is not a private company, or holding company is a company which is not a subsidiary. I mean, these kind of approaches, much before in the Upanishadic wisdom, you will find the same approach, perhaps more profound, and this time deep-rooted, equally corroborated, substantiated, and very difficult to make a rebuttal of. Okay? Perhaps I think I have made a trespass over the next speaker, and I will control my temptation here to talk. Thank you so much for patient listening. Thank you.
Thank you, sir. Thank you for sharing your insightful comments on Akanksha and Mimansa and its application in education and research today. Our next speaker, Professor Arunath Sampath, worked as a research assistant for the project entitled the Deccan Commissionerate, commissioned by the University of Pune under the guidance of Dr. Sushma Verma. She worked as a lecturer in history in Symbiosis Society's Arts and Commerce College, Pune, in the junior college. Appointed as a visiting faculty from the academic year 1992 to 2003. She was appointed as a full-time lecturer in Symbiosis Society's Law College from 2003 and was subsequently confirmed as an assistant professor in the institution. She also worked part-time as a part-time coordinator at the Pune Center of IGNOU. To discuss about the critical overview of the ancient and medieval Nyaya system, I would like to invite Professor Arunath Sampath.
Good afternoon. I know it's a pretty heavy subject this is, and post-lunch all of us tend to drop off. It's very difficult to keep awake. And at the outset, I want to thank Gurpur ma'am for inviting me and for placing her trust that I can deliver something. I hope I can deliver something because most of the issues or most of the points have already been covered by speakers in the morning as well as the speakers now. And respected members on the dais, Dhatrak sir, Ashutosh and my friend Shelke, Atmaram Shelke. So here I begin my discussion not with going into too much, because first of all, let me admit I am not a law person at all. I have no training in core law. Whatever I speak, it is more the periphery one and not the core. And so here I would like to begin with a term called Matsya Nyaya. You might have all heard about this. This Matsya Nyaya is nothing but the law of the fishes or marine species. And we know that they, by nature, the fishes, the bigger fish will always attack the small one and try to, if I want to use a crass term, gobble it up. Or in other words, it's like Darwin's theory, survival of the fittest. So to prevent this, it says the Shanti Parva of the Mahabharata. Shanti Parva is one of the sections of the Mahabharata, like Sabha Parva and so on. It mentions that they did try to, there was Matsya. It starts off with this premise saying that there was total peace in society, which is very rare. I cannot believe that to be true. It sounds a little exaggerated to me. However, that is what is mentioned, that there was total peace, and this peace comes to an end due to the greed of man, which I can understand very well. Man by nature is greedy, man by nature is envious, he wants to overthrow the other person, he wants to have one-upmanship and so on, all the negative qualities in man. And that led to the Matsya Nyaya. In other words, there was a breakdown in law and order in society. And in order to bring that law and order back to society, it was said that the Lord himself entered and he created a constitution, or he created a body of laws, which he gave it to the first king, and that is what the story goes. So, in other words, what we see here is the fact that no society of human beings, leave the animal kingdom. Animal kingdoms can survive on instinct. But in the case of human beings, since we are thinkers, we think, we have a mind, we have a conscience. So our tendency is always to try to overcome the other person, or try to believe that we are better than the other person, or try to put down or be very humble. So there are so many varieties of human beings. So what we do understand is, to regulate human beings, we need something in the form of a body of laws or a constitution. And that was given, they say, to the first king, and he could not become an autocratic king or a despot, and he couldn't be a menace to society, but he was bound by these laws, is what is said. So coming to our sources of law, as it has already been mentioned, one of the primary sources of law in ancient world, ancient India, was the Vedas, the 4 Vedas, out of which the Rig is supposed to be the oldest, and you've heard all that. You've also heard the fact that, which is what I was also going to say, that is Aparushya. Aparushya, maybe because it was not written by man as such. We all understand if something is written by a human being. It was not written by man, but it evolved over a period of time. That is what is probably meant by Aparushya, and it comes all under a body of knowledge called the Shruti. Shruti means that which was heard. And then as time passed, it became very difficult to understand the Ved, and there arose another body of knowledge which was the interpretation of the Ved, and that was the Sutras. Sutras meaning aphorisms or strings of knowledge. Then in course of time, even the sutras became very difficult to understand, and that led to the creation of a body of knowledge called the Dharmashastras. So the Dharmashastras really became your smritis. That became that which was remembered, which was written down. You can probably believe it was written down. And some of the famous ones are like Manu, Narad, Brihaspati, and the others. They wrote the Dharma, the Smriti, Dharma Shastras. They all came under. Now again, there is a misconception thinking that one human being wrote the Manu Smriti, which is not totally true. Manu actually stood for mankind, Manav. It was Manav mankind who really created the Shastras, and that is how it was called Dharma Shastra. Now, overriding all this in our Indian way of life, in our Indian knowledge, in our Indian thinking, in our Indian psyche, is the overriding concept of dharma. It says that dharmo rakshati rakshitaha. In other words, dharma protects the protector. We have heard too much about this dharma recently in our, even in our contemporary society. We keep hearing some politician or some minister somewhere, somebody in the government has not followed his dharma and so on. So we keep hearing about this, but the fact remains that dharma is the overriding concept in our Indian way of life. What is this dharma? Dharma is very difficult to translate into English because it covers, as normally it happens in our Indian way of life, it covers many things. It has a multiple meanings behind it. It is righteousness, it is morality, it is also duty, it is the way of life. It covers many aspects. So they say, yato dharmasto tato jayaha. Where there is dharma, there will be victory. Now, ancient India championed the cause of dharma by believing in the idea of cosmic order. So they said, we are not going to transgress this dharma. The dharma cannot be transgressed as long as we follow the cosmic order. So they believed that the cosmos has a particular defined path to follow, and Rita, they said, is a regulatory of the universal process. Law that was applied was generally based on customs and traditions of the land, which in turn conformed to the divinely ordained norm of good conduct according to class and caste. In other words, though the law was supposedly there in the Dharmashastras, but the Dharmashastras had to be definitely compromised, or it had to agree with the customs and the traditions of the land. So the customs and the traditions of the land got incorporated in the Dharmashastras. So some of the features of jurisprudence in ancient India were the Smritis laid down rules of procedures, technicalities. All cases, they believed, were to be tried by a bench of judges only. A single judge, they felt, could not deliver justice. It was always based on a bench of judges. Evidence was compulsory. It could be documentary evidence, it could be witnesses, or it could be possession of incriminating objects. In India also developed. In India, as the society started developing, it also gave birth to 6 systems of philosophy. Some of them were referred to by Atmaram and Professor Ashutosh. So the 6 systems of philosophy were Samkhya, Vaisheshika, Nyaya, Mimansa, Vedanta, and Yoga. These were the 6 systems of philosophy, or 6 doctrines. I'll come to that. Some peculiar things that you hear is, we come across is, laws were not legislated by noisy bodies. Why I say this is compared to the Roman civilization, where laws had to be legislated definitely in the Senate, because first of all, they went about conquering many countries, the Roman civilization. So they had to incorporate those laws and they had to legislate it in order to be able to govern and administer. Society was the womb, it was the cradle of laws in ancient India. Laws were not divorced from society. Its birth and its development was in and from society. Here I quote from a book written by Nagendra Singh, who was a judge in the International Court of Justice at The Hague. He says, though danda here stands for law, danda here also stands for punishment. Danda also meant, if you do the direct translation, it's a rod, it's a stick to beat up somebody. So he says, though danda is the central pivot of the theory of state, its concept is regularized and restricted by dharma. Hence, ancient India states were in no sense military states. Coming to the 6 systems of philosophy, I'll take up a few of them because the rest have all been anyway covered. In the Samkhya system, which is supposedly the oldest, its crux is divine agency is not essential for the creation of the world. So it suited very well with Buddhist way of interpretation of the religion or philosophy. It came very close to their understanding. All these systems are centered around the pursuit of knowledge of the ultimate. So you must understand in our Indian way of life, what is very important, in our Indian philosophy, in our Indian psyche, in our Indian development of religion also, you can believe that what was important is that we are the seekers of the ultimate truth. When I say the ultimate truth or salvation, means we believe that this is what is also believed in the Mimansa way of, in the Mimansa philosophy. They say that a person is born repeatedly, or as they refer to it, is the Atman and the Brahman. The Atman is the one that is inside the human being. The human being, the flesh is dispensable, and what remains is your Atman. So the Atman and the Brahman is the ultimate one. So they say that it is believed that the soul or the Atman will be born again and again and again until it acquires knowledge of the absolute truth or the knowledge of the Brahman. This is the belief in our Indian system. So all the systems are generally centered around the pursuit of knowledge of the ultimate. The aim of the Atman is to break away from the cycle of births and deaths and to unite with the Brahman. Even a little bit of any negativity or anything which is not acceptable, non-acceptable, will lead to the Atman being born again. So this is what, so being born is considered a punishment. And that is why when kings in ancient India, if they did not deliver justice, they said not only would it impinge on the person who has perpetrated the crime, but it also falls on the king, because the king had not done his duty. Since he has not done his duty, his Atma is going to suffer. That means he's going to be born again. He's going to suffer the pangs of being born on this earth. Because being born on this earth is considered to be a real suffering. It's a punishment, it's a suffering. The yearning of the Atma is to generally break away and to get united. If it is the Advaita philosophy, it wants to get united with the Brahman. If it is the Vishishta Advaita philosophy of Ramanuja, it doesn't want to get united, but it wants to get to the nearness of the Brahman. So the exhortation, so in everything over here you find that fear is instilled in the king as well as the man who commits some crime, that both need to do whatever is prescribed for them in their way of life. If they don't do it, if the king doesn't punish the offender, or if the offender doesn't confess to the fact that he has done something wrong, then he has to suffer a number of births and deaths, a number of person deaths, until he can expiate the whatever sins that he has committed. In the Samkhya doctrine, as it has already been said, this pursuit of knowledge is by pratyaksha. Pratyaksha meaning perception, anumana meaning inference, and shabda meaning hearing. In the Nyaya system of knowledge, knowledge was pursued by analysis and logic. A statement can be tested by inference, hearing, and analogy. It's these factors that influence the development of legal systems in Indian jurisprudence. Now I'm going to come to another very interesting thing which I came across. I was reading about this on the net. Professor Amartya Sen, he has written an essay called "What Should Keep Us Awake at Night" from the book The Country of First Boys. He says he distinguishes between niti and nyaya, a hair-splitting discussion he carries on between niti and nyaya. He believes it is important to distinguish between an arrangement-focused view of justice and a realization focused view of justice. It is not just the existence of institutions and rules of behavior that justice is being done. Niti stands for organization through which justice is done and rules of behavior are followed. While Nyaya, he says, is more comprehensive and envisages preventing severe injustice or Matsya Nyaya. Nyaya is trying to prevent injustice and doesn't aim to create a perfect world. Like slavery in the US, he says that there was a fight to get rid of slavery or to demand rights for the blacks in the US, because it is not that they were aiming to create a perfect world, which is impossible. You cannot create you know that there are always deficiencies, there are always negativity, there are always problems in the world, because it is between two human beings. No two human beings can ever agree on anything, and no two human beings can be replicated, duplicated, or whatever you want. So each one always goes his way. So he says that the fight for slavery, abolition of slavery, was not because the affected people fought for the removal of slavery, not expecting a perfect world, but the removal would result in lessening of injustice. So Nyaya is applicable for the formulation of rules of evidence and reasoning which were applicable in disputes. Even today, Nyaya is a method of reasoning which is used in arbitration of disputes, while Vaisheshika accepted only two reliable means to knowledge, direct observation and inference like Buddhism. Now here I would like to add, I'm not going to prolong my talk for a very long time. I know it's being bombarded with too much of information. So what I would like to add here is that ancient India believed that it was very important for a king to deliver justice. The justice, as far as justice was concerned, ancient India relied on or encouraged the use of justice delivered by the panchayats or courts at the lower level, at the village level. The village was a microcosm of the kingdom. People lived in close proximity. They were generally either part of a very extended family. So all civil disputes that arose in that village was decided by the headman of the village, the Gram Vriddha, along with a number of elders, most of them big landowners. They gathered together and they decided disputes. And most of the disputes pertained to land. It was always an emotive issue, land issue. Then, of course, there was robbery and so on. But then severe criminal issues were never to be decided by the panchayats. It had to be decided by the king's court. And what were the punishments that were awarded? Now, before we come to the punishments part of it, what was also important to remember is the king most of the time would refuse to handle cases unless it was decided at the panchayat level, at the village level. It was the village which was given a lot of importance, so much so during the reign of Adil Shah of Bijapur, Ibrahim Adil Shah, I believe he said that he would not listen to a case which involved a Muslim and a Hindu unless the case was brought directly to his court, and he said he was not going to decide the case unless and until it was decided at the panchayat court. So importance was given to the cases being tried. Why so? The reality was that the reasons behind it was that people were familiar with the persons concerned. They knew whether these are capable of doing such acts, wrong acts, or are they innocent or are they guilty. So they knew all the story behind each of the cases that were brought to their court. And therefore, they believed that the best people to decide were the village elders themselves. And also because probably it would take them a long time to travel because of the mode of travel available. It would take them a long time to travel to the king's court to be heard by the king. And though, as far as the punishments were concerned, the punishments that were awarded, I believe, for killing a Brahmin. Here again, you find that what we would probably consider today to be inequality, which probably the ancients did not believe it to be unequal, is because of the fact that they accepted the fact that they were born in that particular varna. So they have to go through whatever was expected out of that varna until they do good deeds in that birth, and then hopefully in their next birth they overcome these and are born in a better status. So for the killing of a Brahmin, they said it was 100 cows to be paid as compensation. For killing a Shudra, it was, I know it's politically incorrect to use the word, but that is what our books say. So they said for the killing of a Shudra, it was only 10 cows. So such inequality did exist. Everything was not hunky-dory as sometimes it is made out to be. It is not so. There were such inequalities, whether we don't have any recorded evidences if people did protest against that inequality, but it did exist. And when there was no documentary evidence or witnesses, all those were first tried. And if everything failed, the last resort to, right up to the medieval period in our Indian history, you find that they resorted to what were known as the ordeals. And the ordeals, some of them sound pretty brutal. Some of them are not very comfortable to hear. They said they would make the person who's considered guilty or who comes with the issue, he's been blamed by somebody. They would make him hold an iron ball, red hot iron ball. And then then the hand would be removed and it would be tied with a cloth. And 3 days later, they would remove the cloth to see how far the wound has penetrated. Has it become septic or whatever it is? So that was one ordeal that they had to go through, which sounds to me extremely brutal, but that's what they did. And the other one was hot oil. They were very fond of this hot oil. So they made the guilty person put his finger in the hot oil and remove it again, tied it up. So these were some of the ways in which people were being punished, ordeals were resorted to, and that they said they had to resort to the ordeals because it is left, now it is beyond our pale, it is going to be Almighty God who is going to decide. Thank you.
Thank you very much, ma'am, for sharing your valuable insights into the ancient and medieval Nyaya system. Our next speaker, Advocate Shravantarya Tandra, is a founder of Chambers of Shravantarya in Bangalore from July 2022. He's an extensive trial and appellate practice for 14 years, having represented domestic and international clients as a lead counsel on a range of complex matters, including the enforcement of a variety of commercial and contractual obligations, interim measures, enforcement and challenges to arbitral awards, intellectual property rights, direct tax laws, white-collar crimes, real estate, matters involving the review of governmental and administrative actions. He worked in different top-tier law firms also as a senior associate. Today he will be addressing the topic, Property and Wealth from the Perspective of Bharatiya Gyan Parampara, Ancient Dispute Resolution from a Criminal Law Perspective. I invite Advocate Shravantarya Tandra to start his address.
Good afternoon, one and all. Thank you for the kind introduction. The topic that I have been given is substantially, it covers all aspects of law. That is to say, the three systems of the substantial law, namely the Dharmashastra, Arthashastra, custom called the Sadachara or Charitrika, and the preliminary aspect of the traditional system, where the Vedic law had the wife and the husband as the joint owners of the household and property. Of the various Dharmashastras, one interesting aspect of the Yajnavalkya Smriti recognizes the woman to claim 1/3 share of the property, where the recent judgment of the Honorable Supreme Court in Vinita Sharma versus Union of India also recognized that irrespective of the date of marriage, as per the Hindu Succession Act, if it's a daughter of a particular family, she is entitled to have a claim. The relevance of the mythology, which is equally important with regard to any property dispute and even to the ancient knowledge. In Ramayana, it was a particular incident where Lord Rama had to go to forest was Kaikeyi wanted the kingdom in the name of her son. And in the forest, when Lord Rama had met Sugriva was locked in a fierce dispute with Vali. And in Lanka, it is also during the similar circumstances. In Lanka, Ravana had a dispute with Lord Kuber, who had built the kingdom in Lanka. That apart, numerous conflicts, references, there were disputes among the Devas and Asuras, and these disputes eventually led to an accepted norm for the evolution of law, dharma, righteousness, etc. into the very concept of dispute resolution, which primarily started out of property. Now, the other aspect which we equally see is in Mahabharata, where Pandavas and Kauravas were, as a common knowledge, it was a dispute with regard to Kurukshetra. And in fact, the early phase of mediation, which was recently enacted by our government as the Mediation Act of 2022, the earliest reference of mediation also was there when Lord Krishna tried to mediate between the brothers, and again it was the conflict of the property which actually defined the society and what they possess. And the other important aspect is, if we think property is the truth, then trapped or myth or delightful realm of what the Hindu sages called it as the Maya. Now these are other aspects of the knowledge systems. Having said that, with this brief introduction, we now come to the point of property. Now, as per law, as per the legislation, as per the courts, property refers to the owned assets, including tangible and intangible possession. This was the initial definition. Then, wealth contains the total value of the individuals or entities' assets, including property and other financial resources. Now, this is the common practice that we understand what property is and wealth is. Now, when we go back to the ancient knowledge, the concept of property and ownership was different. It was differentiated as a personal status among the free persons in various positions of power and subordination. And there were obligations which are contractual and tortious. Traditionally, as per the Vedas, property referred to as interest in domestic animals and goods, and on few occasions less tangible entities to those categories. One did not say this is my property, as one would say now, where we all approach to the court for a suit for declaration, injunction, specific performance, etc. It was just said, I have property in it, or the property of it is with me. Therefore, property was only a characteristic or attribute of a particular cattle or jewel or a sum of money. But in the modern day, it is a shortened reference to the thing in itself. That is to say, I have to get an order by the Honorable Court to declare that Mr. A is the absolute owner of the property, of the scheduled property, etc. Therefore, in the olden days, it was only a characteristic or attribute of a particular sum of a money or jewel or cattle. Further, debt was also classified as a property of a creditor, and these were also divided as civil pleas into proprietary and possessionary. The treatment of actions of property or for possession were real, which in jurisprudence we say in rem actions, and personal, in personam actions arose ex contracto, ex delicto. The further evolution of law as law of things, where most rules of ownership, its acquisition and its transfer could be phrased without reference to any distinction between land and or other things, which eventually led to corporeal or incorporeal that were being capable of an individual appropriation. In short, what we see today is everything in which a person could have is property, and when negated or questioned otherwise, culminates into a dispute. The action on the administration of justice during the olden days, the best example that I can think of is the tax aspect. To understand both the property tax and the wealth tax. Now, property tax is imposed by a particular kingdom when the assessed value, irrespective of the status of a particular owner, there is always an assessed value of upon determining the value of the property, where that particular fund is used for the development of the particular district or that particular kingdom. Similar to what we see today, a property tax is imposed, and with the roads, schools, sanitation, etc., they are all built upon such tax which is obtained. Now, wealth tax, which is on the other hand, is on the net worth of the individuals, including assets such as real estate, jewelry, cars, etc., cash, and more and so forth, calculated where the total value of the taxable assets after subtracting liabilities aim to address the economic inequality, which is the crucial aspect, that is the economic inequality, by taxing the accumulated wealth of individuals. It's a very good move by the union government during the 2015-16 finance budget, where the wealth tax has been completely abolished to avoid inequality. In short, the disputes with respect to the claims, etc., the earliest account can be traced back to the Arthashastra, where the Prime Minister of the first Mauryan Emperor, the administration units were divided as Sthaniya, Dravanamukha, Krivitka, Sangrahana, which are equivalents to modern day districts, tehsils and paraganas, where each Sangrahana law courts had the meeting places of districts, and the eminent jurists were called Dharmasthas, where great jurists such as Manu, Yagnavalika, Katyayana, etc., Bruhaspati and others, and during the later times, as regards the procedure, it was the Vachaspati and others, where when we take the modern day, we see the village courts, Munsif, civil judge, district judge, high court, and the Honorable Supreme Court. So the structure was there, where the earliest account is found in the Arthashastra. And if there is the Chief Justice during the modern times in Arthashastra was called Pradavadika, who even the attire was prescribed, which was called the Vinita Vesha. He has to be not intimidating and he has to be pleasantly addressed. And it is also very important where the aspect of Dharmasanam, which is similar to the Simhasan, Dharmasan, it has to be impartial, which finds the reference to the oath of impartiality when the honorable judges take the oath. The oath of impartiality finds its significance from the son of Mimansa, which is none other than Lord Yama, where the god of death, who is impartial to all the living beings, the dispensation of the aspect of impartiality has to be to the aspect of being impartial to being the living beings when the life is taken away by the god of death. That also is to be impartial. That is how the oath has to be, is the dictum of the olden law. To go further, there is a very interesting play which is called the Mruchakatika, which is written by Shudraka, also called as Simhyavasana. The aspect of judge and the aspect of the king, that is what we see in the modern day criminal system. There is something called the judgment being delivered and the quantum of punishment which is being awarded. Now both are even today done on a different dates. When the accused is convicted, the sentencing happens on a different day. This also finds reference to the olden day where the question of innocence or guilt of accused was decided by a judge, but quantum was left to the king. And in fact, this finds a reference to our old text called Mruchakatika, when I just said, where I quote, where it says the decision with regard to Charudatta or the innocence lies with us, that is the Dharmastapanas, who are the judges, and our decision is binding, which is called Pramanam. But the rest lies with the king. So this was always there, where the quantum of punishment has to be decided by the king, but the judgment called the Pramanam has to be determined. In the modern day, what fascinates me modern day is irrespective of the medieval times that we have sailed, the British time, the British India phase, etc. Even in the modern day, there is a place in Karnataka called Dharmasthala Manjunatheshwara temple. It's a Shri Kshetra Dharmasthala Manjunatheshwara temple, where the court system is followed in the name of the justice, is in the name of the presiding deity, where there are serpentine queues to get the dispensation system through the Dharmadikari. And in fact, the disputes such as the money lending, marital disputes, the civil disputes have been popularly called Hoilu. It's called the Hoilu system of court in the Shri Kshetra Dharmasthala, where the Dharmadikari is none other than the presiding deity himself, who is a Sankalpa which dispenses the justice, and the resolutions have happened, and even the courts, the district courts in Karnataka and even the High Court have upheld the dispensation system of the Lord Manjunatheshwara, and there is no court fee. If the settlement has been agreed between the parties, voluntary contribution is given by the parties, and it is also believed it's very rare that the dispensation system in Dharmasthala has an ex parte order, because once a particular Shara has been addressed to the other party who has complained of a dispute, it is believed that he will be present in the temple premises, and it has been more so all throughout. And to conclude on an aspect of dharma, which is very, very difficult, but I take my reference through Subhashita, which says, Chinnopi Chandranataruhu na jahati gandham vruddhopi vapnapati na jahati labam yantrarpito madratati na jahati chekshu shinopi nyatejati shila gunan kulinaha, which exactly translates as, no matter how much you rub the sandalwood, it never loses the essence and it can still go on producing it. No matter how old the businessman is, he is never ready to lose his profit. Sugarcane, whenever it is being crushed to pull out the sweetness, it can never lose the sweetness to an infinity. Same way, no matter what the difficulties are and no matter how difficult the things go on, one person cannot lose the attribute of his character, that is to be fair. With that, I conclude my perspective on the ancient dispute resolution from the criminal law perspective and property wealth from the perspective of Bharatiya Gyan Parampara. I thank my law school again. It's a return to me. Thank you.
Thank you very much, sir, for your valuable inputs into the discussion on property and wealth from the perspective of Indian knowledge systems. We have received several questions for this plenary session. However, for the want of time, we will go through maybe one or two questions. One of the questions was, how did the Mauryan and the Gupta Empire influence the present-day Indian legal system? And I suppose maybe Aruna ma'am might be a good person to take this question.
Well, mainly, in my opinion, how it influences the modern system is through the arbitration. Arbitration is where you find that probably what existed at that time has influenced even today. I cannot think of anything other than that. As I said, ordeals and other things cannot be performed today by any means.
Thank you, ma'am. Okay. Another question was, how does the Indian knowledge system view intellectual property rights in relation to the traditional legal knowledge? Any of the panel members can take this.
Good afternoon, everyone. At that time, even in other part of the world, there was no process of intellectual property rights. But if you see all our texts, names of the authors are written. And later on also it is pronounced with the names of the author. I was referring to the sutras. So sutra is with the name of the author. This person's sutras. Also with the surtis also name of the authors were there. So everything was connected with the person. Even there was no actual sale or purchase of the intellectual property, like books were not sold or purchased, etc. But whatever was created was connected with the individual or name of the individual. That is, ma'am can add maybe further things.
I would like to add one thing. Perhaps this concept of intellectual property is today a very market-oriented commercial practice. Everything is evaluated in terms of money. You want to make money in everything that you do. Probably that didn't exist even because even a person like Kautilya, whether there was really a person called Kautilya who wrote is still a question mark. We are not sure whether such a person really existed who could write the volume, or it was a contribution made, as I said, like Manav Dharmashastra, Manu's Smriti, where it was a contribution made by a number of scholars of that time. You can't say, but I don't think, because those societies were not hardcore commercial societies like today. Today you open a mouth and you ask for some payment. You ask for a money. So that is where your intellectual property comes. Because when I was learning yoga, my master had said, yoga went to the world and today it is popularized so much in the Western world. But we never asked for intellectual property rights there. We have never talked about intellectual property rights. That's how I would look at it.
Thank you very much, ma'am. Thank you, sir. With this, we conclude the first plenary session. I would like to thank each one of the panelists who have contributed to this plenary session. Thank you very much. We will now take a 10-minute break, and exactly at 4 o'clock, we will start with our next plenary session.
Hello. We request all the students to please settle down. We'll be starting in the next 5 minutes. Please take your seats, students. We request all the students to please take your seats.
Recording in progress.
Good afternoon and welcome back to the plenary second session on glimpses of Dharmashastra, epics of Indian knowledge system or Bharatiya Gyan Parampara and interdisciplinary reflections. Before we begin, I'd like to welcome all our resource persons and dignitaries on the dais. We request Professor Dr. Shashikala Gurpur ma'am, Director, Symbiosis Law School, Pune, and Dean Faculty of Law, SIU, to kindly take the stage. We also request our panelists to please grace the dais. We have with us today Dr. Sneha Sapre ma'am, Dr. Anaka Joshi, and Mr. Kshitij Gupta. Please, sir, ma'am. Let us have a round of applause for our dignitaries. In our second plenary session, we'll be speaking on the subject Glimpses of Dharmashastra, Epics on Indian Knowledge System and Interdisciplinary Reflections. Before we begin, I'd like to request Professor Dr. Shashikala Gurpur ma'am and Mr. Kshitij Gupta, who is the coordinator from our knowledge partner PRAVAH for Maharashtra and Goa. We request you both, sir and ma'am, to kindly felicitate our dignitaries. Yes. We request you, sir and ma'am, to please felicitate Dr. Sneha Sapre, Joint Registrar, Bhandarkar Research Institute, Pune. We also request you, ma'am and sir, to kindly felicitate Dr. Anaga Joshi, Associate Professor, Savitribai Phule University, Pune University. We also request Professor Dr. Gurpur ma'am to kindly felicitate Mr. Kshitij Gupta sir himself, who is the General Secretary for PRAVAH in Maharashtra and Goa. Sir has completed his B.Tech in Chemical Engineering from IIT Bombay. He has also been serving as full-time as a social worker in Seva organizations, and he is currently the General Secretary for Maharashtra and Goa in PRAVAH NGO. Thank you, sir. Thank you, ma'am. Yes. We also would like to verbally felicitate our online attendees and panelists, Dr. Siddharth Dash and Professor Dr. Parmeshwaran. Thank you for being with us, sirs. Thank you, ma'am. Thank you very much. To begin this second plenary session, it is my honor to introduce Dr. Sneha Sapre, Joint Registrar, Bhandarkar Research Institute, Pune. Ma'am has been working as the Joint Registrar and Administrator of BORI Infosys Academic Development Program at Bhandarkar Oriental Institute, Pune. Ma'am has completed her BA, MA in Sanskrit, MA in Marathi, B.Ed, LLB, and Diploma in German language. Ma'am has taught Sanskrit in Abhinava Vidyalaya English Medium High School, Pune for 21 years. Ma'am has worked at the headmistress in Vidyanand Bhavan School, Nigadi, worked as vice principal at junior college at Indira National School, Vakad. She was a member of the Board of Studies for grade 10th Sanskrit textbook and has many articles published on the subject of Dharmashastra. Ma'am has also made and designed a course of 120 videos for learning Sanskrit digitally available at Bharat Vidya platform of Bhandarkar Institute. And it has been very well received by people in and outside India. We welcome you, ma'am, to kindly deliver your lecture on critical analysis of P.V. Kane's Dharmashastra. Please, ma'am.
Thank you very much. Respected Gurupur ma'am, all the dignitaries on the dais, and all my dear friends. It gives me a very great pleasure to stand amidst you and to introduce you a few important topic of history of Dharmashastra, which will be definitely connected to the students of law. Truly speaking, it's a very vast subject, but I'm trying my best to give you the glimpses of this subject through history of Dharmashastra, written by Mahamahopadhyay Panduranga Vaman Kane. He was a great scholar of Sanskrit and Indology. The history of Dharmashastra is a very vast book, and it's a literary work which is conferred by the highest Indian civilian award, Bharat Ratna. He has authored several books. Roughly, I can say Dr. Kane has written around 20,000 pages and into at that time. The scope of Dharmashastra is Achara, Vyavahara and Prayashchitta. I shall be speaking on the Vyavahara part of it, which deals with the legal systems. Now coming to the topic, you all will be curious to know many things about the legal systems in our India past. The meaning of Dharmashastra, the courts, the judges, advocates, substantive procedural laws, law-text, routine of the court's holidays, their ways of pleading, leading evidence, court fees, and many more. Indian polity and judicial system has historical legacies spanning over 2 millennia, showcasing a gradual evolution while maintaining the consistent aims and ideals. We see separation of powers between the legislature and judiciary. The king was the administrator of justice. His foremost duty was to dispense justice and fair resolutions of matters without delay based on the text of Dharmashastra. The texts were written by the Smritikaras and the justice was dispensed by the kings. Thus the legislature and judiciary were totally separate at that time. The term dharma is manifested and broadly interpreted as righteousness or morality. It is distinct from religious affiliations. It refers specially to the moral function of rewarding good and punishing evil. If the judicial function is not done properly, the strong will torrent the weak, just as big fish in the water will devour the small fish in the water. We call it as Matsya Nyaya. In the absence of king and fear from punishment, the social system will totally collapse and disturb the balance in the society. Now the word associated with the judicial system is vyavahara, which more particularly refers to the lawsuits or the matter of litigation, while vyavahara pada means the topic or the subject matter of litigation. There existed 18 distinct types of disputes and conflicts among the people. There was a very clear distinction made between civil and criminal laws. The civil laws were known as dhanamula or arthamula and criminal law himsamula. In the older system, the same court tried both the civil as well as criminal kinds of disputes. They more or less dealt with the most subjects brought about in the modern classification, but due to the scarcity of time, I am really not be able to give justice to these 18 types of lawsuits, which you will definitely find very much relevant to our current judicial system. The law was divided into substantive and procedural. The court of justice or locus was called as Dharmasthana and was also known as Nyaya Sabha, where the pursuit of truth was guided by the sacred laws laid down by the Smritis and Dharmashastra texts. In those days, the courts were constructed facing the east direction and were expected to be well maintained. Thrones were provided for the judges, and the king used to administer the justice in the first half of the day, so the working hours of the court used to be in the morning. The courts has holidays on Ashtami, Chaturdashi, Purnima and Amavasya. The Nyaya Sabha, that is the court, was comprised of 8 essential components or the parts. The king, those 10 components are as follows, like the king, the chief justice, who used to pronounce the law, Smruti, that is the law text, to guide the laws, Ganaka, the accountant, Lekhaka, the scribe, to reduce into writing the procedures of the court and statements of the litigants. Suvarna and fire and water were required for ordeals. The Swapurusha was called as what we call as bailiff in our modern terminology, who used to call the litigants, ensure their presence before the court, and in olden days too, there were protocols for the judges. The king, the Manu says that the king should come to the court neatly dressed and without gaudy attire. He must proceed with his working with undisturbed mind. The king was the apex court at that time, and his decision was final and binding on all the courts. Just like Article 141 of the Constitution of India, it stipulates that the law declared by Supreme Court is binding on all the courts in India. It was the similar position of the king at that time. Before initiating any lawsuit or the appeal, the plaintiff or the appellant pays the court fees. In ancient time too, the fees were levied for the civil disputes, while no fees had to be paid for the criminal trials. This is quite analogous to our current system. We need lawyers to plead our suits, right? Whether there was a system or the institution existed at that time, which we call as lawyers, answer to this question is partially no. But the Smritis allowed sick people, ignorant people, postpartum women to send their representatives. The representatives was appointed by the litigants, and they were not appointed by the kings. The representatives were fined for the professional misconduct. Unnecessarily delay in the legal process was not acceptable at that time. Shukraniti says that Mahan dosho bhavet kalat dharma vyapatti lakshanam. Delay was called as denial of justice. Certainly the judiciary at that time was supportive of speedy trials. Section 95 of Indian Penal Code is based on the maxim de minimis non curat lex, which says that the law does not take account of trivial things. The section intends to prevent the penalization of negligible wrongs. You will find and surprised to know that same provision the Smritikaras has made at that time too. They too said that no cognizance is required to be taken of the trivial matters. Now let us go to the next part, the constitution of courts. The court constituted of the king, chief justice, judges and sabhyas, courteous members of the courts. Now the judges decided the cases in consultation with sabhyas. Chief Justice held a position of authority, but the ultimate decision rested with the king, who was deemed to be the Supreme Court of Justice at that time. There used to be some learned seniors in the courts whose opinions were respectfully received. They were the friends of courts at that time. Their opinion wasn't binding on the court. The concept is applied in the modern times all over the world, which is known as amicus curiae. These are also the friends or the impartial advisors of the court. We find the same thing which was prevalent at that time in ancient India too. Interference in the judicial process was strictly prohibited. Private conversation with the judges was not allowed during the pendency of the suit, and the justice was dispensed in the open courts. The process of dispensing justice, the interpretation of statute is very, very important. Kevalam shastram ashritya na kartavyo dharma nirnayaha. The lawmakers then said that the justice should not be dispensed merely on the basis of the Dharmashastric text. The king and the judges must apply their minds and interpret the law text scrupulously in the interest of justice. Otherwise, it amounts to the death of justice. Typically, the aggrieved person goes to the court to seek justice. However, sometimes even in the absence of a formal complaint, the Raja, the king himself, used to take active role in addressing the situation which demanded action and attention. Narada calls it as prakiranaka, the lawsuits depending on the king's action. Now, current system, we call it as the suo motu cognizance taken by the courts, like high courts and supreme courts. They take such type of cognizance when they feel that the court has to work on its own motion without waiting for any formal complaint. There was a clear distinction made between civil and criminal laws, as I said earlier. The lawsuits were primarily divided into 18 groups. I feel the system is just like the pigeonhole system in our law of torts. There was a clear distinction, civil and criminal laws. This civil law, as I told, was called as Artha Mula, and criminal was Hinsa Mula. The same court tried civil and criminal matters. The trial conducted in those courts was mainly comprised of the following steps. First of all, the receiving information, determining of Vyavahara Pada, consideration of pleading of the parties, hearing the evidence, and lastly, the decision. The litigant were expected to approach the court very humbly. The plaintiff was called as Vadin and the defendant was called as Prativadin. Upon receiving the information, the scribe used to reduce into writing the statement of the complainant. Then the Svapurusha, that is a bailiff, used to call the defendant to appear before the court. Once the defendant comes before the court, the scribe once again used to write down the same contents of the complaint in front of him so that there is no discrepancy, or whatever is given, he is saying is given, the writing in a very fair way. There was no amendment allowed in the complaint, just like we see Order 6 Rule 17 of Civil Procedure Code, it allows the amendments, but amendments were not allowed once they are written down once again by the scribe, and rather for the second time in front of the defendants. Then the petition, after this no amendment, then the complaint used to be finalized. The petition used to the plaint rather, it used to contain the year of the suit, season, time, name of the litigation, list of documentary evidences, name of the court, country, town, occupation, plaintiff and defendant and their mutual relations with each other. Description of the property, names of the ancestors of the kings, all these details used to be present in the complaint. Once the complaint was filed, the defendant was summoned to appear before the court and he was given an opportunity to give his say as usual. That is called as a written statement in the current procedure. The statement wasn't clearly, if the statement not very clearly drafted and if it is ambiguous, it was called as, it is full of dosha called as sankara. And such statement of sankara dosha was inadmissible and was not accepted and it was dismissed at that time itself. After filing the written statement, there used to be arguments of both the parties. The evidences were of four types: oral evidence, documentary evidence, possession and audience. Though the possession of the property was the best proof, it is not considered separately as per the Indian Evidence Act at present. And audience are totally now outdated, we can say. The witnesses were called and the king used to administer the oath for the witnesses. Manu, Katyayana and Narada provide that a proper witness is the one who himself either seen or heard or experienced the matter of dispute. The evidence given by the witness must be direct as per Dharmashastra. Hearsay evidence was inadmissible with a few exceptions, that is, if the witness is dead or he is gone abroad. Narada says that a litigant should not approach the witness nor should he try to win him over by bribing him. Otherwise, he was liable for consequences. On hearing the depositions of the witness, the court used to decide the cases, and if the witness is genuine, they used to decide whether the witness who is leading the evidence is genuine or is a prejudiced witness. The false and hostile witnesses were fined at that time. Documentary evidence was the primary evidence and the documents bearing king's seal was considered that a prima facie genuine, just like the public documents dealt under the provisions of Indian Evidence Act. See, in the process of finding the truth, the witness may lie but circumstances may not. Corroboration of facts with circumstances was very important at that time too. The documents having contradictory or ambiguous statements were not accepted in the evidence at all. The principle of the natural justice, it says that no innocent person should be punished. Apastamba Dharma Sutra says that nacha sandehe dandam kuryat. No one should be punished if there is a room for doubt. The prosecution always has to prove the case beyond reasonable doubts and benefit of doubt is always given to the accused. Now the last leg of the litigation is the judgment, Siddhi or Nirnaya. The judgment, that is Jayapatra, it was given to the successful parties, as we say the award of the judgment. So those days Jayapatra, the winning party was getting the Jayapatra and losing party used to get Hina Patra. Now Vyasa provides for the contents of the judgment, what content should be there in the judgments. It has a brief statement of the plaint, the reply, evidence, depositions of the witness, discussions thereof, arguments, smruti texts applicable, and the opinion of Sabhyas. The decision of relief granted was written after that. The judgment should be signed by the king, that is the Chief Justice, and should bear the royal seal. When the dispute were decided by the domestic tribunals, there was no Jayapatra, but it was Nirnaya Patra. As we see now, the judgments are given in the courts, and these type of courts, they used to give Jayapatra only in case of the matters dealt in the courts, but the matters, if they are adjudicated outside the court, they were given the Nirnaya Patra, just like the awards we say at this time. Friends, we have reviewed the polity, the law, the procedure in early India. Upon observing it scrupulously, we can conclude saying that the judicial procedure involved in India, spanning over 2000 years, is certainly of high order. It is also to note that a substratum of all the branches of philosophy is the pursuit of truth, and ultimate purpose of the legal system resonates with the quest Satyameva Jayate Na Anrutam. Students, before I conclude, I cannot stop myself giving you one advice. While studying this system of law, I request all the students, the researchers, and all of you to go in search of primary resources. Just reading the books, I understand it helps you all, but at the same time, I request all of you to have a look at history of Dharmashastra once before going ahead with the research in this field. Thank you very much.
Thank you very much, ma'am. Thank you for that in-depth analysis of P.V. Kane's Dharmashastra, along with a comparative approach to the current legal system. And thank you for your presence here today. Our next speaker for today is Dr. Anagha Joshi, Associate Professor at Savitribai Phule, Pune University. Ma'am has worked as an Assistant Professor at the Center of Advanced Study in Sanskrit, University of Pune. She has also delivered special lectures on linguistics arranged by Sanskrit Samvardhan Mandal, Sangli, in April 2009. She has successfully completed a refresher course on information technology with A grade in October 2010. Ma'am was appointed as a lecturer in the Department of Sanskrit and Prakrit Languages, University of Pune from November 2006 to 2007. Ma'am was appointed as a research associate in the Center of Advanced Study in Sanskrit, University of Pune. She was also an assistant professor at the Center of Advanced Study in Sanskrit, University of Pune. She has been awarded with the Mahadev Keshav Athavale Vedant Prize for first rank among successful candidates at the MA examination, and was also awarded with the Kuperkar Sanskrit Prize for first rank among successful candidates at the MA examination. We are delighted to have you with us today, ma'am, and we invite you to deliver your lecture on critical reflections of the Shanti Parva and Valmiki Ramayan from the perspective of Indian knowledge system. Please.
Good afternoon. The title of my topic is Critical Reflections of the Shanti Parva and the Valmiki Ramayan from the perspective of Bharatiya Gyan Parampara. First of all, I would like to thank the coordinators for giving me this opportunity to get associated with this event. In fact, in a gathering of these lawyers, I feel out of place because I come from a Sanskrit background. Only I am doing research on Dharmashastra, Arthashastra and Mimansa, which are related with ancient Indian jurisprudence. The Indian knowledge system, that is Bharatiya Gyan Parampara, rooted in ancient wisdom and philosophy, encompasses, I have made PPT for the sake of understanding of the audience because I come from Sanskrit background and my article is focusing on Sanskrit texts. So I have made PPT, please have a look. I think everybody is in awakened state now. The Indian knowledge system, that is Bharatiya Gyan Parampara, rooted in ancient wisdom and philosophy, encompasses a vast array of disciplines, including philosophical systems, that is darshanas, astronomy, mathematics, medicine, literature, law, commerce, arthashastra, that is public administration, finance and foreign policy, and management. Sanskrit language has played a significant role in the preservation and dissemination of knowledge throughout Indian history. Sanskrit is rightly recognized as the greatest possession of India. It is known for its rich content. The Ramayana and Mahabharata occupy a revered position in the Indian tradition. The Ramayana is regarded as the Adi Kavya, and the Mahabharata is an Itihasa, a Purana, an Akhyana, a Samhita, a Kavya. Besides this, it is a Dharmashastra, Arthashastra, Dandaniti Shastra or Rajaniti Shastra also. A close study of these texts are required to understand the concept of welfare state in the then society. In Kautilya's words, the king's happiness lies in the happiness of the subjects, and in their welfare, his welfare. The king should not consider as good only what pleases him good, but regard as beneficial to himself whatever pleases his subjects. Praja sukhe sukham radnyaha, prajanam tu priyam hitam, na atma priyam hitam radnyaha, prajanam tu priyam hitam. Dandaniti, it is one of the oldest names for this Shastra. Dandaniti literally means the use or employment of the rod, and it refers to the earliest method of inflicting punishment to wrongdoers by the ruler. Danda or punishment governs all subjects, and punishment alone protects them. Danda remains alert or is awake at night when the whole world is asleep. Therefore, wise people consider danda as dharma, that is the very essence of righteousness. Dandaha shasti praja sarva, danda eva abhirakshati, dandaha supteshu jagarti, dandam dharma vidurbudhaha. The term dharma is derived from the root dhru dharayati, means to hold, to bear, to sustain, to support, to preserve, etc. It refers to the right or proper conduct, and it covers English concepts such as ordinance, law, usage, customary observance, morality, duty, religion, attribute, quality, so on and so forth. It is rightly stated in the Mahabharata as dharanat dharmam iti ahuhu, dharmo dharayate prajaha, yasyad dharana sanyuktaha, sa dharma iti nishchayaha. Duty, that is dharma, is so called because of dharana or its nature of support. Dharma upholds people at large. So, dharma is that which is possessed of dharana. Last but not the least, there is one more important aspect also. The well-known rule that every right has a correlative duty is embodied in the word dharma, which is indicative of both right and duty. That is why in our ancient tradition, we do not come across the concept of right, but only duty is mentioned, duty-based society. In the Ramayana and Mahabharata, it is not the king's rights, but his duties that are specifically stressed. The Shanti Parva extensively deals with Rajadharma, which pertains to the duties of the king and the government. The presence of certain elements are essential for any state, regardless of its form of government, which has been expounded in the renowned doctrine of Saptanga Rajya Prakruti, that is natural constituents of a state. They are Swami, that is the ruler, Amatya, the minister, Janapada or Rashtra, that is territory, and the people in the countryside, Durga, capital city, Kosha, which is most important, treasury or economy, Danda, army, and Mitra, that is ally in foreign policy. It is rightly stated in the Mahabharata and Rajadharma Parva as Saptangasya cha rajyasya viparitam yaha acharet gururva yadiva mitram pratihantavyaha eva saha. If a person acts against the interest of a kingdom under these 7 constituent elements, be it a teacher or even a friend, they must indeed be opposed or resisted. The Swami or king takes precedence as the most important element in the affairs of the state. However, no ruler, regardless of competence or power, can manage the state single-handedly. It is rightly stated as Sahaya Sadhyam Rajatvam Chakramekam na vartate Kurvita Sachivaus Tasmat Tesham cha Shrunuyan Matam. The kingdom cannot function without assistance, as one wheel alone does not turn and keep the cart in motion. Therefore, king should appoint ministers and listen their advice. The term Sachiva Tantra can be used to describe this system. In other words, we may say that a form of government where real power exists in the hands of ministers. It is argued that a single amatya would be difficult to control. Two might quarrel, 2 amatyas or 2 ministers might quarrel and ruin the state or conspire against the king. So according to the circumstances, the king may hold consultations with 1 minister or with 2 or even none and should take a decision by himself. It seems that the efficiency of administration depends on good ruler and capable ministers. The 2 epics explain the 6-fold policy known as Shadgunya, which guides a king in determining his policy with foreign states. Ramayana clearly states that Shadgunyasya padam vetta niti karta cha raghavaha. The 6 policies enumerated under Shadgunya are Sandhi, the policy of peace, Vigraha, that is actual war or the policy of hostility, Yana, that is marching on an expedition, Asana, the policy of remaining quiet and not planning to march on an expedition, Sanshraya, seeking shelter with another king or in a fort, and Dvaidhi Bhava, that is the double policy of Sandhi with 1 king and Vigraha with another at the same time. The appropriate use of 6 measures enables the Vijigishu, that is the would-be conqueror, to play with other kings just as he wishes. They become puppets in his hands. The inclination to dominate weaker neighbors is natural tendency of human beings, and our king is not an exception. The institution of Duta and Chara serve as vital instruments of security for a king. Traces of such diplomatic agents can be found in Sanskrit literature. Valmiki calls the Dutas as the eyes of a king and declares that the wise king should gather the information of his enemies through them. The distinction between a Duta, that is envoy, and a Chara, that is spy, where the former being an open representative of his master, while the latter a secret one. The responsibility of a Duta was great, so the treatment accorded by the enemy to the Duta and the Chara differed in as much as the official status of the 2 are different. The former was an open representative of his master, while the latter was a secret agent. In the Ramayana, Hanumana announced himself as an envoy or as Duta of Rama. Dutoham iha sampraptaha Ragavasyati tejasaha. But Ravana had given death order against him. In the Sundarakanda, it is stated as, and Vibhishana states, Rajan dharma viruddham cha lokavruttescha garhitam vadham na kurvanti paravaradnya dutasya santaha vasudhadhipendraha दूता न वध्याः समयेषु राजन् सर्वत्र सर्वेषु वदन्ति सन्तः असंशयं शत्रुः अयं प्रवृद्धः कृतं हि अनेन अप्रियमप्रेयं न दूतवध्यां प्रवदन्ति सन्तः दूतस्य दृष्टा बहवो हि दण्डाः. So in short, the killing of a duta is in every respect inappropriate, going against the principles of the code of conduct and deemed reprehensible by social ethics. Messengers are not to be killed at any time. Despite being an enemy who has wronged you immeasurably, the righteous do not advocate for the killing of a duta. Several other punishments for an offending duta have been prescribed, such as disfigurement of the body, shaving the head, etc. Accordingly, Ravana ordered that fire should be set to Hanumana's tail and that he be taken around the main roads of the town. In short, dharma, whether it be Raja dharma or Duta dharma or Sadharana dharma, was a strong directive force in the then society and governed the entire behavior of the individual as a member of the society. To conclude, today the world is different and many things in the tradition may seem irrelevant in modern times as time is changing very fast and science has advanced to a very great extent. But there are certain principles which will remain there forever and which will be tested on today's needs but will never be discarded. This is an ongoing phenomenon as interpretation is the basic need of humanity. Human nature has remained the same through ages. Hence, many of these rules are still applicable, only the contexts and details may have changed. What is needed is a genuine interest in going deep into this age-old ancient Indian knowledge system that is Bharatiya Gyan Parampara. Thank you for patient hearing.
Thank you very much, ma'am, for the knowledgeable lecture. I'd also like to mention that ma'am is currently the professor at Department of Sanskrit and Prakrit at Savitribai Phule University, and she has also completed her PhD from the Center of Advanced Studies in Sanskrit. Ma'am has also been awarded a number of awards such as the Pandit Satwalekar Puraskar and a major research project on revisiting the intellectual history of Sanskrit jurisprudence from ICSSR with a grant of 12.71 lakhs. Ma'am has completed a number of research projects. She has been invited to a number of talks, and she has also written 2 books called Sambuya Samutana and one on non-payment of wages as a ground for litigation in ancient Indian law. Ma'am has guided 3 PhD fellows, 2 MPhil fellows, and is currently also guiding 6 people on their research. Thank you very much, ma'am, for your lecture today. Let's have a big round of applause. Our next speaker for today will be joining us online, who is Dr. Siddharth Shekhar Dash, an Associate Professor from KIIT School of Law, Bhubaneswar. Sir is presently an Associate Professor and Head of Department of Criminal Law and Criminal Justice Administration at KIIT School of Law. He also worked as the Standing Counsel at the High Court of Odisha with more than 10 years of teaching experience in the field of criminal law and other laws. He has 27 publications, 5 patents, guided 8 LLM scholars, and undergone more than 6 faculty development programs to his credit. Sir's articles include one titled Expanding Frontier of Neurolaw Post Srimati Selvi versus State of Karnataka, and Neuroscience Perspective of Conduct and Causation in Criminal Law in India. He also finds a special mention of these 2 articles in India Neurolaw under the MacArthur Foundation Research Network on Law and Neuroscience by Vanderbilt University. we welcome you, sir, to deliver your lecture on Neurolaw jurisprudence and Indian knowledge system, mind theory, a possibility. Welcome, sir. Sir is facing a few technical difficulties, and so we'll continue with our next online speaker, that is Professor Dr. K. Parameshwaran, who is the Professor of Law at Gujarat National Law University, Gandhinagar. Sir is currently the Professor of Law at GNLU, Gujarat. He also was the former Dean of Academics at GNLU. Sir has taught at NLSIU Bangalore, NLU Jodhpur, Madras University, and SLS Pune. He has pioneered a law subject called Law, Religion, Spirituality and Justice and Ethics Skills Development for Professional Integrity and Excellence. Sir is a master trainer in Neuro-Linguistic Programming or NLP, Cognitive Behavioral Psychotherapy, CBT, and Integrated Clinical Hypnotherapy and Solution-Focused Brief Therapy, that is SFBT. He is in the advisory board of Project for Integrating Spirituality, Law and Politics in USA. He has had lectures in India and abroad on spirituality, education, and legal and justice research, keeping Sri Aurobindo's integral consciousness approach for individual and collective well-being. He also conducts a number of workshops for students, advocates, judicial officers, PhD scholars using spiritual and psychological practices, and he writes regularly on these themes and contemporary issues. We welcome you, sir, to kindly deliver your lecture on integration of law, religion, spirituality and justice from the perspective of Bharatiya Gyan Parampara.
Thank you very much. Am I audible?
Yes, sir, we can hear you.
Okay, thank you. Greetings and namaste to every one of you present here. I am indeed honored to be present before you all on this important occasion, an auspicious day that is being celebrated in the Symbiosis Law School, Pune, every year, in a way in which it can generate new ideas, new insights for a greater humanity. What I want to share today with all of you is that the Bharatiya tradition, the Bharatiya knowledge, or the Indian knowledge system and so on, is something very important for law. As a result of which the integration between spirituality, law, religion and justice is something very interesting for all of you. And I would even say that it has become indispensable right now. I will quickly outline four major aspects of the Indian knowledge system, or the Bharatiya traditions, or the ancient traditions, whatever name that we want to give. It rests on four important things: the ancient Indian knowledge, the Bharatiya value system, or the Indian knowledge system, has four major classifications. Though there are minor classifications, But I would like to speak only on the 4 major classifications which are useful for law, religion, spirituality and justice, and this integration which is happening. Classifications are: 1, the Indian knowledge system, the Bharatiya tradition system, has the first understanding that there exists a belief in the mind, there exists a belief in the mind that there is the highest consciousness. There is a state of existence which is very high in consciousness, in awareness, which is beyond all, beyond everything, not only beyond all and beyond everything, but also inside everything and inside all. Which means it is not only transcendent of all, but also immanent in everything. It is also present in everything. So the first understanding is a belief in the mind that there exists the greatest consciousness, the highest state of existence, which is transcendent, which is immanent, and it is ever present, eternal, and it is everywhere, universal. And it is from this, everything else comes, everything else flow. It is from this, everything else originates. It is from this, everything else sources. And it is in this, everything else lives. It is in this, everything moves. And it is in this highest state of consciousness, the highest state of existence, the transcendental, the universal, the immanent, in which everything is played out and it plays, and it will always be, and it will go on. So this is the first understanding of the Indian knowledge system or the Bharatiya traditions, whatever name, broad classification that we want to give. 1. Since it is a belief system that is there in the mind of everyone, it is there in the mind of all, it is there in the mind of human, that there exists such a thing, which is universal, transcendent, immanent, from which everything else comes out, from which everything else lives, from which everything else moves, and it is because of this it is living and it is continuing. The second aspect is, there is a need for developing this inside every human. There is a need for developing this growth. There is a need for evolving into this state of consciousness. There is a need for evolving into this state of existence. And how do we have this need fulfilled? It is by self-experience. It is an experiential thing by which we grow, layer by layer, plane by plane, and then we move to the highest state of consciousness, that higher state of consciousness. Currently we know the physical, the nervous energy level, the emotional, the feeling, the thought, and it goes on. This is the second most important aspect of the Indian tradition, the knowledge system, the Bharatiya value. The third most important thing is that there is a system of knowledge with very rich variety of diversity and multiplicity that we cannot even think of, which touches every aspect of life, which deals with every aspect of life, in which this possibility of developing and self-evolving in each and everything towards that. And finally, the fourth of it is that each and every individual at an individual level, social level, community level, they have their own way to grow, they have their own method to grow, but towards that. Just give a quick recap of all the four, and then I get into law, religion, spirituality, and justice. Is that the ancient Bharatiya tradition, the integral knowledge, the Bharatiya knowledge system, is that there is a belief imposed in the mind that there is a great highest state of existence, consciousness, which is transcendent of all, but not only transcendent of all, but also immanent in everything. Not only transcendent and immanent, but also universal. Not only universal, but also eternal and continuing forever. And it is from that everything originates, it is in that everything lives, and it is in that everything moves, and it is by which things are what they are. The second is, there is a need to grow towards that, there is a need to develop towards that, there is a need of evolution which is happening, which is because of that secret existence from inside, from above. And that existence, that experience of that existence is by experience. It is an inner experience matched with the outer. And the third most important, a wide variety of knowledge systems are brought, such a diverse approach to knowledge, such a multiple levels of knowledge, layers of knowledge in each and every aspect of life, in each and every layer of life. Not even a single aspect of life is left out. Everything is involved in that, been explored in that. This is the system that has been placed. And finally, each and every individual, according to their growth and development, each and every one in the society, in the community, they have their own way to approach, but only towards that. So these four important ways, or four important classifications, which we can call it as the ancient knowledge system or the Bharatiya traditional system and so on, is something very useful for integrating in law, integrating in religion, integrating in justice system and so on. How? If you see, the whole legal system talks about three things. The whole constitution, the charter of any country at a national level talks of three basic things. They say equality, they say liberty, they say fraternity. And they also add dignity, unity and integrity. So the three broad categories, this is what they call it as justice. So when we are able to manage and balance and harmonize equality, liberty, fraternity, dignity, unity and integrity without disturbing that fine balance from inside and from outside, that they have named it as justice, whereas the Indian system calls it as dharma. So this, the legal formulation that we have, the constitution that which speaks about equality, liberty, fraternity, unity, dignity and integrity, can be very easily understood, can be very easily explored, can be very easily realized, can be very easily manifested if we know, if we accept, if we understand, if we experience that consciousness, which is the highest state of existence, the highest state of consciousness, which is not only transcendent but also immanent in everything. Everything else originates from that. Everything else lives in that. Everything else moves around that, and it is because of that it is continuing. And what is continuing is something universal. And what is continuing in this whole thing, that which is universal, is eternal. So by catching hold of that thread, the spiritual fabric, the spiritual thread, the spiritual experience from inside, deep inside and above, we automatically feel the sense of oneness that is spreading everywhere, the sense of unity that is underlying everything, which in constitutional language we can call it as equality, and at a very crude socio-political legal level, the principle of non-discrimination. So what we know as equality is basically a principle that has originated from there, from above, from inside, which is the principle of oneness, the principle of unity, the principle of the union. It is that principle, that highest state of consciousness, existence, transcendent, universal, immanent, eternal, which is everywhere, which is in everything. Everything else originates from there, everything else lives in that, everything else moves around that. As a result of which unity is held, as a result of which unity is there already. So by experiencing the thing which is present in everything, we get to the experience of the oneness itself, the unity itself. As a result of which the social, political, economic equalities an output. One. The second aspect of the legal dream, the constitutional dream, the guarantee is the liberty. When will you know that everyone is free? When will you know that everything is free? Only by going into the principle by which everything else is being held by that one single consciousness, which is not allowing any kind of a clash. The clashes are happening only at the lower level, only at the external level, because we have not caught hold of the unity principle. If we catch hold of that consciousness which is uniting all of us, we get to know that everything exists for its own space. The very ideal of liberty, the very ideal of freedom is that only. But without having it, we are trying to artificially construct it from external. It's fine, not a problem. At a social level, at an economic level, at a political level, we can do that. But still it is not at all stable. When equality is emphasized more, liberty gets cancelled. When liberty is emphasized more, equality goes down. When liberty and equality, they are actually not balancing, fraternity goes down, fraternity goes off. And fraternity, equality, liberty goes up, obviously unity, integrity, dignity goes off. So we must catch hold of that principle, that experience of that which is inside us, above us. The third aspect being the fraternity. When we feel the sense of oneness, when we feel the sense of the freedom, we actually feel fraternal, we actually feel the love. As a result of this equality that comes from the principle of oneness, the experience of oneness, as a result of this liberty which comes from the principle of the experience of the freedom to move around, and the fraternity which comes as a natural byproduct of that, as a result of which everyone feels the sense of life, that is dignity. When everyone feels the sense of the life, unity and integrity is automatically maintained. So I teach in GNLU a subject called Law, Religion, Spirituality and Justice. It is basically to emphasize that. So one is to understand academically that spirituality and religion is very important. The Indian tradition, which is very important. The ancient knowledge, which is very important. The Bharatiya tradition, which has explored all this as a system, is very important and it is indispensable. In fact, it is this which is going to help the constitution work. In fact, it is this which is exactly what the legal system is aspiring for, but they don't know how to do it. The constitution has only given us the goal. The constitutional ideals, the preambular ideals, they are all actually a derivation of the spiritual principle put outside externally as one kind of a seeking, one kind of a wanting, one kind of a desire. But it's not happening. Even if it is happening, it is only happening at a very lower level or at a very external level, but still the stability is lost. Stability is not rooted. It's precisely because of this lack of experience of it. Now a question comes. It has to be taught in the law school, in which the religion plays a very important role. How do we do that? You can take all the religions, whatever religions that one is interested in pursuing. I teach 9 religions. Each and every student is free to explore their religion, but in terms with this unity, in terms with this eternal, in terms with the universality, in terms with that oneness, in terms with this principle of non-discrimination, in terms with that union, in terms with fraternity and freedom and liberation. So it is an individual thing which has to happen. As a result of which the individual, when he is experiencing it, he is obviously bringing it outside in the society. As a result of which the individual human being and the social being merges here with one single experience. This has to be first academically taught, academically studied, academically researched. And this also will be of very great rescue, a help, a remedy for even the religious, socio-cultural crusts which are actually fighting. Because we are getting into each and every religion the core principle of experiencing that oneness, experiencing that freedom, experiencing that liberty and so on. So this is the need of the hour. I'm very happy that this is being taken time and again at the Symbiosis Law School, and I have been fortunate enough to work in Symbiosis Law School, Pune, say 10 years back. And we have our professor there, Dr. Sashikala Gurpur, with whom I had enjoyed great conversations on this topic. She is a great exponent on this. And this needs to be explored in full length. This needs to be studied in full length. And currently, with artificial intelligence coming into picture, giving all kinds of knowledge, with information technology and information highway coming into picture, everything is almost full. There is only one requirement. It is to get into the self-experience and replicate the same thing in the professional space and in the social space, in the political space. That is the need of the hour. And for that, the knowledge system of the ancient systems, the Bharatiya traditions and its values come to our rescue. This is what I wanted to share here with all of you. And I am very happy and very honored to have shared these insights with this prestigious law school on this most important auspicious day. Thank you so much for giving me this opportunity. Thank you very much.
Thank you very much, sir, for that wonderful lecture, and thank you for joining us online. We also have with us online Dr. Siddharth Shekhar Das. He was unable to join before due to certain technical issues, but sir is with us here now. Sir is currently the Associate Professor and Head of Department of Criminal Law and Criminal Justice Administration at KIIT School of Law. We welcome you, sir, to deliver your lecture on Neurolaw Jurisprudence and Indian Knowledge System, Mind Theory, a Possibility. Welcome, sir.
Thank you. I hope I am audible, because there was some technical glitches for which I could not able to join earlier. I thank the host institution for considering to conceive such a beautiful line of thoughts which will provoke the mind of the students to consider, reconsider, debate, fertilize their idea regarding the Indian justice delivery system in the light of Bharatiya Parampara. Here in this case, without consuming much time, I would straight away go to the research aspect, which currently we are undergoing so far as criminal law jurisprudence is concerned in the context of the Neurolaw jurisprudence as well as Indian knowledge system, a possibility which is to be explored. When I say that there is an existing Neurolaw jurisprudence, it sounds little awkward or it sounds little strange. How can there may be an amalgamation of neuro as such law? Well, neuro law, well, it is a term which is nowadays used conveniently to address all those issues which are coming, the research which is undertaking in the field of neuroscience, which are having the implication in the field of law. When we see this picture, well, if we see this picture, in one of the pictures you see the famous Arusi murder case, wherein the Nupur Tarwar and Rajesh Tarwar, they were involved and made accused of offences. And in another picture you see a person is considered as a ISI handlers and also an encyclopedia and having various information in his mind. And in the third picture, the infamous and treated criminal terrorist Afzal Asaf, who was involved in the parliament in the Mumbai terrorist attack case. In all these aspects, the investigating authority wanted to use the brain mapping, brain fingerprinting as a part of the investigation and try to unravel what is operating in their mind, how the information that can be solicited from their mind can be used for the purpose of the investigation. Well, the merit of the information that was derived from their mind, whether it can be used in the court of law as an evidence or not, or it can only be used for the purpose of investigation, has been debated in case of Indian judiciary in Selvi versus State of Karnataka. But without going into these implications, when we see the background under which these things are operating, we find, I see, that these brain mapping, brain fingerprinting, and for that matter, any MRI which is conducted, functional MRI which are conducted, all these are related to a robust science called neuroscience. And it is having an implication in the field of law. So the convenience way of understanding and tapping the knowledge of neuroscience in the field of law is used as a neurolaw. Now, if we try to see the research in the field of neurolaw, the MacArthur Foundation Research Network on Law and Neuroscience gives the statistics that in the year from the year 1984 to 2009, the research in the field of neurolaw is ever increasing. The total cumulative publication in case of law and neuroscience, if you see, is always increasing in trend. And there is still scope of research, and the research would be made in the light of the fundamental question that arises in the case of law, which still are unresolved, and can the neuroscience as having a scientific temper can address these questions are some of the challenges of this field. Now, if we see another statistics, the use of neuroscience in criminal law cases in case of USA from 2005 to 2015, if we see, the neuroscience has been used by the criminal defendant consistently, and it is increasing over the period of time. Now, coming to various literature which is existing so far, well, few of the literature I have discussed. One of the article which was written by Michael S. He states in his Free Will in 21st Century, a discussion of neuroscience and the law. He discussed that the issues which are surrounding the study of the neuroscience and law are compelling and observing in nature. Much work is needed to further clarify the complex issues which are arising both in the domain of law and the brain sciences. Well, a lot of issues arise between the law as well as the brain sciences and their intersection, because some of the fundamental questions that arise is the methodology which is adopted by the law for the purpose of understanding a fact situation is entirely different to that of the methodology which is adopted in the brain sciences. Here the author tries to show the possibility that there are scope for the further research on certain directions. Another author, Hans Kung, in his article, Controversy over Brain Research, Downward Possession and Neurobiology of Free Will, states that the philosopher and theologian can no longer discuss the nature without taking the findings of the neuroscience into account. What he hinted here in this article is that there is an existence of the free will which the law always tries to recognize for the purpose of criminal responsibility. And the free will not be discussed from the theological point of view, and oftentimes when we try to assign the free will from the context of the morality, which is rooted mostly in the theological tradition and religious tradition. This free will now will not be discussed from the context of the theology, rather it will be taking shape from the neuroscientific point. That means it will be having a scientific temper which can be producible before the court of law if the research is taking place in the right direction. Likewise, John Owens, in its Law and Neuroscience, states the importance of the neuroscience in the legal discipline. He says that the extent to which legal system can avail itself the best of the neuroscience has to offer will depend in parts on the extent and quality of engagement between the neuroscientist with the myriad researchable issues that which are already existing, as well as many other issues that may inevitably arise in some time in the future. Likewise, Francis Xavierson, he is a pioneer in this law and neuroscience. In fact, he was the lead researcher who led this MacArthur Foundation research network on law and neuroscience. He discussed the future engagement of the neuroscience and law and tried to cast 15 different possibilities of the engagement between neuroscience and law. Well, these are some of the literature which are available in the field of neuroscience and law. Now, here we'll try to see the possibility of the Indian knowledge tradition, from the jurisprudence to the Indian knowledge tradition, more specifically the theory of mind which is existing in our Indian knowledge tradition. In the passing, I would like to say that Indian knowledge tradition is having a robust theory of the mind. How far we can explore that, how far we can accommodate with the current pace of research which is taking place, more particularly in the field of neuroscience and law, which conveniently called as Neurolaw, is the possibility. Here first, the study of neuroscience and jurisprudence, conveniently called as Neurolaw, has to be tapped, has to be assigned, has to be debated, has to be seen from various contexts of existing body of research which is taking place in case of law or legal discipline. Then we are to see the possibility of the theory of mind which is existing in the field of Indian tradition and to explore the possibility thereof. Now, if we see so far as jurisprudence discipline, when it tries to understand certain fact situation, tries to address certain fact situation, tries to resolve certain fact situation, it sees from the context or prism of the jurisprudence. And in case of jurisprudence, the interaction has to be a healthy one. Earlier period of time when the research in the field of sociology was taking place, it was not immune from the law. So we found that whenever there was an interaction of the legal science with the sociological field, we say and assign that yes, there is a sociological school of jurisprudence which considers law, actual fact as phenomena. Likewise, there are various other schools of jurisprudence like positive school of law, which is most of the time applied in the criminal administration of justice, because when we try to understand law, law is as it is. It is the expression of the legislature, and the legislature expresses through any statutes. So, for the purpose of analysis, in case of positive school of law, and sometimes also it is called as analytical school of law, it tries to interpret a fact situation from the interpretation given by from the interpretation which can be borrowed from the statute or the meaning of the word which is expressed by the legislature, and that is the true meaning of the law. Now, in this context, taking further, if you see normative school of jurisprudence, it tries to say the law is not simply certain what it is the expression of the legislature, but it is a host of the things wherein the law is reduced to a normative situation. And normative situation means the expression in case of odd situation. X and Y analysis, wherein even if X situation is not prevailing, that does not negate the situation of Y analysis, which most of the time, if we see in other social sciences, if the existence of X is not there, then the existence of Y also can be questioned. Here, law is reduced to an atomic aspect, and even if sometimes normative aspect says that it is pure theory, that means it is divorced from the value of any other values. Nevertheless, there is a scope for us to understand whether the normative situation, what we are seeing, can profitably borrow from the neurological findings or findings from the neuroscience. So also from the natural law school. Natural law school, which most of the time considers law as the eminent of the reasons of the persons. The reasons of the persons, that means the law has to be reasonable in nature. When we see about the neuroscience and all these aspects are concerned, it tries to anchor in its principle certain biological aspects as well. And the invariability of the happening of the thing, whether it is in one country or in another country, that is the basis which can be taken into consideration by the law for the formulation of the new laws are concerned. So these are various schools of jurisprudence, and whenever any aspect or any tradition or thought wants to interact with the law, it has to go through, or it has to undergo the ordeal, or what we say, the churning of the jurisprudence. And in this analysis, when we try to see the Neurolaw, and in the context of various schools, whether it is from the context of the positive school or natural school or any other schools are concerned, there is a possibility. So far as when we try to at hand apply in the criminal administration of justice, one of such schools I have taken for the purpose of discussion. Here, when we see the positive school of law, when a fact situation is analyzed from the context of the law, which is discussed by the legislature through the forms of a word, various interpretations are taken into consideration. Whether the interpretation is strict in nature, whether it is pervasive in nature, or whether it is to suppress the mischief or advance the remedy, in all these aspects, the findings which are taken by the Neurolaw can be a basis for the purpose of incorporation by the judges, and when it is incorporated, then the jurisprudence, what we see from the positive context, will be taken into the real sphere. Whatsoever that possibility, the compelling situation that arises from the findings of the neuroscience, the law cannot immune from it. The better that we shall try to assign the findings of the neurolaw, neuroscience or psychology in one of the jurisprudential aspect, it is better for us to take an interdisciplinary research, and both neuroscience and law would be profitably associated from it. Another aspect which I confine my research on the field of criminal law is to see the association of the neuroscience in the field of criminal law when it is trying to interact in various aspects. When we try to say that, well, neuroscience is interacting in the field of criminal law, means it is having two aspects. First, whether in fact it is interacting with the cardinal principle of laws, and second, on the aspect of the expression of mens rea, the interaction is there. So far as cardinal principle of laws are concerned, criminal laws are concerned, illegality, causation, harm, act, utility, these are some of the cardinal aspects. So far as causation is concerned, criminal law understands causal relationship, cause and effect relationship. That means an action is done by an individual and it is having the effect of a crime, or a crime has happened due to some kind of causes which is originating somewhere. Well, in all these situations, the causal relationship between the action of an individual which is resulting in the crime, the cause and effect relationship, which most of the time also the law of evidence takes into account under Section 7 of the Indian Evidence Act. If we try to see in the context of neurolaw jurisprudence, then the neuroscience can be either the cause of the crime or it can be the effect of the crime. That means, if suppose a person is committing an offense due to some neurological condition, under that circumstance, the neurological findings can be the cause of the crime. And subsequently, if a crime has been committed in an individual, and subsequent period of time, say for an example, the individual undergoes a traumatic experience. Here, due to the crime, the person is going to a traumatic experience and it is a neurological condition. Here, the neurological condition is the effect of the crime. In either way, The association of the neuroscience can be taken into consideration either from causal aspect of the cause or effect relations. So far as harm is concerned, when we try to talk about criminal law, the fundamental constituent of a crime is harm. There cannot be constitution of any crime without considering harm. If there is no harm, then there is no harm. So harm, what we understand, it is the harm to the body, mind, reputation, property. But when a normative science tells about harm that is not understood by the medical science or neuroscience, they understand the same harm in different domain, in different perspective. So far as neuroscience is concerned, it takes into consideration pain aspect of an individual, and it tries to criteria the pain. When in case of neuroscience, there is a robust literature existing which illuminates what are the pains and pain criteria for scientific assessment. If you see the suffering, grief, depression, fear, anxiety, disturbance of emotional experience, all these are painful experience which the person undergoes.
Sir, excuse me, sir.
Yes.
Sir, if you don't mind, due to paucity of time, would it be okay if we conclude in 2 minutes, sir, please?
Okay.
Thank you. Thank you, sir.
Okay. So in this aspect, if we see the relationship between neuroscience and criminal law is concerned, it is robust. Now, here, the aspect so far as Indian knowledge tradition is concerned, the Indian knowledge tradition is having a robust aspect of the theory of the mind, the popularly understood aspects, the popularly understood research, the popularly understood concept like I am the author of this action, I am the author of this action means whether I have done an act intentionally or not. I know this fact, I have this knowledge, I believe, I was attentive or not attentive. All these aspect is robust in Indian theory of the mind. Indian knowledge tradition, which states regarding the theory of mind, mind is generally addressed as Manasa. Peter Sejmler states that almost unknown to Western academics, psychologists, there is a huge collection of ancient Indian thought system, and this thought system cover all aspects of the psychology such as cognition, behavior, personality, emotion, and value and volition aspect. Well, why this has not been entered into Western textbooks? Because these are not purely psychological in nature, and it is considered that there are certain elements of religion. First, we consider, let us, Veda. In Kathopanishad, the metaphor which is used for the purpose of understanding mind, senses, object, and intellect is just like mind is the creator, intellect is the creator, mind is the rein, sense is the horses, and object of the sense are the roots. That means the sense of horse explores the road, and the senses are reined by the mind, which ultimately is reined by the buddhi or the intellect. This is the expression so far as to understand the operation of the mind and how it is operated by the intellect or the buddhi. So far as Mandukya Upanishad is concerned, it is providing a robust literature so far as understanding the layers of consciousness. It is researching, it is living the mind as it is and considering the consciousness aspect of the person. And it is stated in this way that it is stated in the 4 ways. First, when the action of an individual begins.
Excuse me, sir.
Yes.
Sir, very sorry to disturb, sir, but we really have to conclude very soon.
Okay.
Yes, please, sir.
So possibility, if you see in case of research is concerned, the possibilities are there that in case of Indian knowledge tradition, how the cognition, behavior, personality, emotion, and volition, all this research can be further externalizing the research, the religious content, and outrightly religious content, and not outrightly rejecting the same. For this purpose, if we try to see the very existence of the mens rea, which says the constitution of the crime, gives us an basis and inspiration to enrich our jurisprudence. And for this reason, if we try to assign the neuroscience in the field of a separate domain of jurisprudence, like psychological school of jurisprudence or neuroscience of jurisprudence, under this aspect, if we try to explore the possibility of Indian theory of mind, the Indian theory of mind can be profitably be assigned for 4 or 5 broad purposes. First, it can be for the rehabilitative measures of the offender. It can be for the prevention of the crime. It can be used in the courtrooms. It can be formulation of new criminal responsibility. It can be assisting in the investigation of the crime. That apart, when we are trying to integrate the Indian knowledge system, we cannot play an exclusionary role. Moreover, when we try to search the explore the interdisciplinary empirical research, it can be taken with existing hypotheses which are existing in the Indian theory of mind, and scientifically can test it. Peter Sadler states that, well, the mainstream Western psychology, if they begin with the theoretical foundation and explanation of the phenomena from Indian context, then it will be profitable association rather than it will be non-profitable association. So, due to the limited time, I could not able to express all those aspects. And but in short, it is that there are possibilities to integrate the Indian theory of mind in case of a criminal jurisprudence in association with the neuroscience jurisprudence. And thank you.
Thank you, sir. Thank you very much for that very interesting lecture on Neurolaw jurisprudence and Indian knowledge systems. With that, we come to an end of all the speakers. We thank all the panelists and dignitaries for your presence here. We'll just move on to a few questions. Due to paucity of time, we'll only take one question. One very relevant question is with respect to what practices can teachers use in using the Indian knowledge system to enhance their teaching learning experience. So if any of the panelists are willing.
In ancient Indian tradition, Gurukula system was there. And apart from that, Shravana, Manana and Nididhyasana. These 3 steps, if teacher and student will follow, then it will help a lot. It's my opinion. Shravana means to listen carefully, then student should think over it, and then try to apply in your daily activity and in your study also. Thank you.
Thank you, ma'am. Yes, ma'am.
One thing I would just like to say, if you have looked at the literature of Upanishad, the teaching learning method was interactive and it was never a direct method or a lecturing method at all. And that was the best method of teaching, which I feel it's very useful for the knowledge systems. And another thing is that the educational system that leads students to think and to question is the best in my opinion. Thank you very much.
Thank you very much, ma'am, and thank you to all our panelists and Kshitij sir as well for participating today. And now I'd like to request Professor Dr. Shashikala Gurpur ma'am, Director, Symbiosis Law School, Pune, Dean, Faculty of Law, SIU, and Jean Monnet Chair Professor to kindly deliver the concluding remarks on the unfinished agenda, responses, meeting expectations, and more importantly, curriculum development. Please, ma'am.
Good evening, respected panelists, offline and also watching online, all the colleagues from other sister law schools and all the audience here, including the faculty, staff, students, and students from outside of Symbiosis. I'm not here for very long to bore you or to try your brain fatigue's patience, but we need to give a proper shape to what we have done since morning. So this is a small attempt, a quick attempt to do that. First of all, you would have loved, the prelude I wanted to give before the first panel discussion was about what you would have loved to contextualize. They say that mindfulness is the one which keeps the mind in the present. If you see this very auditorium, this itself is a reflection of Indian knowledge. The traditional knowledge, the creativity of the people from the remote area in India, from the northeast. That's why it's appropriately called Ishanya. And secondly, I wanted to tell you that the sense of justice need not have law degree as such. Sense of justice, as in the Indian sense of dharma, is about this harmony, about this peace-loving status, the equilibrium. So in India, the focus was more on the outcome rather than the means that was used. And the means in terms of process, procedures, substantive and procedural law distinction, all this is the kind of structured contribution by the colonizers or the colonial or imperial interventions, because they could not break through the complex centuries-old culture of India. So the best way was to create an alternative culture or impose something on that culture. The ideal way would have been integrating. So such approaches have emerged in the Supreme Court, right from Justice Patanjali Shastri's judgments till today, especially incorporating Tirukural and other kinds of folk wisdom, aside from alludations to Bhagavad Gita and other things in the Supreme Court judgments. Professor Ishwar Bhatt, if he was here, he would have given you a host of decisions where our current court has made a lot of references to our ancient knowledge. Now, I don't know how many of you have felt a sense of injustice if you have gone through Mahabharata, when Drona refuses to teach any other disciples than Kshatriyas. Then Karna raises a question, who is he? About Drona's own son Ashwatthama, who is not a Kshatriya. So such questioning of what Madam said in terms of questioning, such questioning has always been the essence of our tradition. Nachiketa's questioning about questioning his father and father's anger, and then he goes to the death god Yama, and then he raises those substantial existential questions. So questioning has always been there. Second aspect that comes in Mahabharata is the Yaksha Prashna. In Yaksha Prashna, the testing of Dharmaraja in terms of his adherence to dharma, the values. This narrative comes in the form of Yaksha taking the form of a big crane and challenging Dharmaraja when his brothers go to consume water from the pond where this crane was visible, and they die, and then to test his patience, the question was asked, if I give you one choice, whom you will bring back to life? Instead of choosing his own maternal brothers, the three younger brothers, he chooses to keep back to life the twins who are his last younger brothers, last set of younger brothers. The reason is that he says that among my mother's children I am alive, among my stepmother's children let one be alive. So this is the way in which self-sacrifice and sense of justice was visible throughout in ancient Indian tradition. So with that in the background, let me quickly run through the kind of survey that we had conducted among students, faculty, experts, including the people from other outside of Symbiosis Law School, Pune. So these reflections, one by one, quickly we'll run. This is your own reflection, because when we conclude, I told you in the beginning, at the end of the manthan, there should be Navaneet, or the butter, or the essence that is brought out. So to bring that essence, we also did a pre-event survey. And in that, these questions were very much revealing. See the question here, are you familiar with the term Bharatiya Gyan Parampara or Indian knowledge system? It's very interesting to see that 85% of them were familiar. That means somewhere the sense of justice and sense of law, beyond the textbooks and learning of law through the structured BCI developed curriculum, always existed. So this is one point. Come to the second one. Rate your understanding about the Gyan Parampara. This is a little startling that nobody says it's very high. Nobody says it's high. Very small, 10% people. Majority of them said that their knowledge is very, very moderate. So that shows that there is a need for a curriculum, or there is a need for integrating this with the curriculum. Let's go to the third question. That is about what are the sources from which you know. Everybody, see the thing, self-learning. That means we are asking those critical questions, and we are trying to see when India is poised to grow, it is the time for us to assert our ways of knowing the world as well, right? which includes the understanding of justice and law in terms of peace and coexistence. So some of them have gone through the social media, but part of the course curriculum is very, very small. Very small percentage know it as part of the course curriculum. Let me tell you, it doesn't mean that we don't refer to Indian knowledge system. When I teach international law, my colleagues also, they would refer to laws of war, they would refer to the diplomatic immunity in terms of the dialogue between Hanuman and Vibhishan and Ravan in Mahabharata, that a king's representative should not be hurt, should not be killed. So diplomatic immunity, which we see as Vienna Law of Treaties in 1969, it was already there in our culture for centuries. Let's go ahead. So there is another question on, are you aware of the subject as mandatory subject? Nobody has it as a mandatory subject. There is not even integration. So should it be mandatory? 70% said it should be mandatory subject, because there could be teachers who don't have any awareness of these epics, especially maybe my next generation teachers who are going to come. They may not even know, because we grew up in households where every day Ramayana or Mahabharata was read, discussed. At least once a week there would be sittings. Many of us, majority of my age group. But we did not pass on that kind of a culture to our children. We got urbanized, we had other ways. But still, when these stories were read, children would be all ears. But the thing is, we don't have that kind of time. Therefore, putting it as part of curriculum from the childhood as you grow up will be something that everybody felt should be mandatory. Let's go ahead. I think many of our international friends who come here to study, I have some international students here, they would also love to know, as they see all the cultures around India, they would want to know the ancient roots of this culture. Who wouldn't want to know? So, which branch are you most familiar with? Everybody is familiar with yoga, because we all want beauty, we all want health, we all want good posture, and yoga has been popularized. That's only the beginning. Everybody knows Ayurveda because it has got long-lasting solutions. People know about Nyaya, people know about Dharma as a concept, but how deep do they know? That is the issue. Let's go ahead. I think there are many such questions that reading of Bharatiya Gyan Parampara, anybody has read. Many are aware, but very minuscule have no knowledge, about 11%. Let's go to the next question. So we have a lot of questions. So these questions were aligned with today's discussion as well. So number of them, majority of them know about yoga and meditation. I think we'll go to the last question instead of the discussions today, because one or two questions came here. We discussed property, we discussed criminal law, we discussed neurology, we discussed the concepts from Ramayana and Mahabharata, the Shanti Parva. We discussed about the Dharmashastras. Let's go to the last one. How do we integrate, which Professor Param, law faculty would have already, senior law professor would have already told. From there, and even the consciousness which another professor mentioned in Neurolaw, if we are looking at curriculum development, the question that comes is, that slide, we asked the question about what kind of assessment. Everybody said it should be reflection based, because you are not already having the command or material. So we need to first of all develop the content, make that content student friendly and faculty friendly, and enable the faculty with the capacity building. Therefore, reflection based method, open method is the best. Next, what kind of curriculum development should we have? So that's my last part. Now, one, we have realized that in a legal education or in any education, there are multiple stakeholders. Quality assessment in NAC has identified it as community, as government, as teachers, as parents, faculty, students. So what kind of approaches? We already have an Indian approach which is very different from Socratic approach. In Socratic approach, teacher raises the question and student answers. In Akanksha method, student raises the question and students answer among themselves. That's much more learner-centric and learner-driven and learner-empowered. We taught this methodology for all our PhD students from 2010. Whereas this methodology is present in the Sanskrit academies, and it is very much used in the Vedic studies. So this is the method we want to resurrect and to present to the world. So in our project on 21st century skills in training teachers for future, we brought in Akanksha method and integrated into the AI-based methodology as impromptu learning method, where you come prepared and the knowledge evolves in an impromptu manner with the creativity, with everybody's participation. It is called the approach to construction of knowledge, which is 21st century thing, which is not teacher driven, which is learner driven. So what is the process that we have to use in teaching? You already know. Assessment, the concepts such as law, justice. Our concept is not which rule to which property, which well. It is about solving a dispute. Therefore, we will go more into situation-based learning, connecting it to the concept of property, wealth, justice, etc. Because in indigenous methods of dispute resolution, which I told you about Banaras Hindu University, now Indian Law Institute is coming out with the publication on indigenous systems. I have a scholar, Robert Hallam, who is looking at community justice in Northeast. So the dispute resolution there is so powerful within the community that virtually the high courts have no work there. So that means we have a system which is already so powerful, and on the other hand we have these courts laden with so much of backlog which will take not less than 100 plus years according to Bibe Debroy if we want to achieve a zero level of disputes. So it's here that we need to unlearn our existing concepts and relearn. And another thing is, do we integrate this knowledge into the existing curriculum till Bar Council comes out with the new curriculum? We can't wait till then. Therefore, one way is teachers, if they're trained, they will integrate, they will publish in that area and create new knowledge. Second is creating specialized course, which can be value-added course, which can be an LLM, which can be a faculty training module, along with the technology-driven MOOC programs. So this is what we would recommend. It could be a certificate or value-added course or part of the course in UG program, PG program, diploma program and faculty development. Let's go to the content. In terms of content, we would suggest that we should have concept of history and evolution in relation to governance, law and justice, where we want to look at something which didn't get discussed today, Yoga Vasishta. Lord Sri Ram, after he came back from Vishwamitra's training to subdue the demons, he comes back to the kingdom and takes a round of the kingdom as a prince. And then he develops a kind of detachment. And then Yogi Vasishta, Rishi Vasishta comes to Dasharath's court and he enlightens the entire court with the officials and the king on the concept of governance. And that is captured in Yoga Vasishta, which has all the Ashtanga Yoga alongside the statecraft ingrained into it. I don't know how many of you have read about Yoga Vasishta. I consider it as a mandatory text for every leader and every teacher and every lawyer and every judge. So Yoga Vasishta's essence is captured in Bhagavad Gita later on because Lord Krishna came after Lord Rama. And then we also have it captured in Patanjali's Yoga Sutra among other texts. And Kautilya to a greater extent draws on this. Therefore, Yoga Vasishta, at least its essence should be taught to students. Arthashastra should be taught. Bhagavad Gita, Rama and Mahabharata. Mimansa, which is interpretation, already the discussion you have seen. And then literature in languages. The sense of justice and the challenges to justice as expressed in various regional language literature, they need to be brought in. We have the translation capacity now with the technology, and how justice and law are across different cultures, including what must have been discussed on Sufi and other cultures. And then we come to Bharatiya Gyan Parampara on constitutional law, which is the mother law, and then we see different specialization areas. We want to bring international law also in context with that in everything, and integrate it in family law, property law, obligation or contract law, criminal law, dispute resolution system, indigenous justice systems everywhere, and then war and peace, and then folklore and marginalized cultures, their knowledge, indigenous knowledge and digitization, how they will interface with digitization, and climate law and justice. There could be civil law. Many areas could be added here, but broadly we want to look at this kind of a curriculum. And we would urge that, as we rightly said, reflection and case study based, we would urge that all parts of India are covered in this, and technology is also administered in this area. So as the first phase, we develop materials. For that, we may float the idea of research internships for students. Second phase would be training the faculty, and then floating the course in the beginning as value-added course, and then developing based on trial and error based on the feedback. So this is the outcome of today's excellent discussion and the kind knowledge sharing that has been done by our eminent resource persons since morning, and also bringing these resource persons to us. and the kindness of the resource persons, their hard work, including our own Professor Aruna Sampath, Professor Ashutosh among others, and the contribution of PRAVAH. So tomorrow when we develop the course, I'm sure that that's going to benefit the whole community of law students in this country and the international students who come here or who may access it online. So with that I conclude, and I am very grateful to every stakeholder who is here and who is remotely connected. Thank you.
Thank you, ma'am, for beautifully summarizing today's event and adding the finishing touches to today's event. As we come to an end of the Law Day Oath Justice V.Y. Chandrachud Memorial Public Lecture and Symposium on Vidhi Manthan, I request our Deputy Director, Dr. Aprajita Mohanty ma'am, to kindly deliver the vote of thanks.
I'm aware of the constraint of time. I'll be short and crisp. We have come to an end of this day's long intellectual discourses on the in form of late Justice Y.V. Chandrachud Memorial Public Lecture and Vidhi Manthan, Bharatiya Gyan Parampara on Law and Justice. On behalf of management of Symbiosis and Dean and Director Dr. Sashikala Gurpur, I stand here to deliver a formal vote of thanks. I thank the resource persons for today in both the plenary sessions, Professor Aruna Sampath, Professor Dr. Atmaram Shelke, Professor Ashutosh, and Dr. Anagha Joshi, Dr. Sneha Saprep, Dr. Parmeshwaran, and Dr. Siddharth for consenting to be a part of this unique symposium, Vidhi Manthan, that is Bharatiya Gyan Parampara on Law and Justice. All of you have very successfully deliberated on various aspects of Bharatiya Gyan Parampara on Law and Justice, and we know this is the beginning of our inquiry into Bharatiya Gyan Parampara on Law and Justice. We thank you for being a part of that process of inquiry, which is already underway from our end. I thank PRAVAH for being a wonderful knowledge partner, and I'm sure we collaborate with you in times to come. And I thank Dr. Sashikala Gurpur for raising the Law Day celebration to a greater height by introducing this unique symposium. As you have rightly said, madam, that the day is not far when it's on, it is in the curriculum of law in the entire country. I thank you, ma'am, for your vision and perseverance. I thank the core committee and the entire faculty team for executing the event. I thank our admin officer, office superintendent, and all the support staff for their able assistance. And last but not the least, I thank the students for being patient audience. Thank you, one and all.
Recording stopped.